The Appellate Division First Department is now in session. Welcome to our virtual oral argument. I will now call the calendar. The first case on is PP versus Tashima. Appellate?
Good afternoon, Your Honor. My name is Jenna Weinblatt, and I represent the appellant.
Okay, you have 5 and 1. For the respondent?
Good afternoon, Your Honor. My name is Philip Tisney for the people.
Okay, you have 5. I'm going to ask everybody who's not actually speaking to mute their microphone so we don't get any feedback. So if you're not actually speaking at the moment, please mute the microphone. Fuse Spirits versus UB Distributors for the appellant.
Good afternoon, Your Honor. I'm William Buckley of Garbarini and Shear for the plaintiff appellant, Fuse Spirits. With me on the line, though, is Mr. Michael A. Fawaz of Howard & Howard's Royal Oak, Michigan office. He's a member of the bar in both Michigan and Illinois, and we request that he be permitted to do the oral argument today.
The motion is granted, and you have 5 and 1. For the respondent?
Good afternoon, Your Honor. This is Joshua Siegel for Fuse Spirits.
Okay, you have 5.
Thank you.
In this case is Michelle versus Luke for the appellant.
Yes, Jason Advocate of Advocate LLP for the appellant, Luke R.
You have 4 minutes. And
Thank
for
you,
the
Your Honor.
respondent?
Sergio Villaverde, the law offices of Sergio Villaverde for the respondent and cross appellant. Good afternoon, Your Honor.
Good afternoon. You also have 4 minutes. The next case is Belfon versus Petosa for the appellant.
Good afternoon, Your Honor. Dean Pillarella for defendants appellants.
Okay, you have 5 and 1. For
Thank you, Your
respondent?
Good afternoon, Your Honor. Howard R. Cohen for the plaintiff respondent.
Okay, you have 5 minutes.
Thank you.
You're welcome. The next case is NYCTL versus Appellate.
Good afternoon, Your Honor. Michael Suture for the appellant.
Okay, you have 5 minutes.
Thank you.
For the respondent?
Good afternoon, Your Honor. Julie Henricks Phillips Lytle for the respondents.
You also have 5 minutes.
Thank you.
And again, if you're not speaking, please mute your microphone. The next case is Union of Automotive Technicians versus Port Authority for the appellant.
Good afternoon, Your Honor. Craig Kozan from the law firm of Witham & Kozan for the appellant.
Okay, you have 5 minutes.
Thank you very much, Your Honor.
You're welcome. For the respondent, Port Authority.
Good afternoon, Your Honor. Paulo C. Alves from the Port Authority Law Department for respondent, Port Authority.
You have 5 minutes.
Thank you.
You're welcome. For the respondent, Port Authority Employee Relations Panel. I know you were here before via audio. Okay, hopefully you will come back when we actually call the calendar and you'll be able to get back online, but we'll go on with the calendar. Prospect Capital versus Latin for the appellant.
Good afternoon, Your Honor. Kevin Galbraith of the law office of Kevin Galbraith for the appellant.
You have 5 minutes. For the respondent.
Good afternoon, Your Honor. Adam Burton for respondent.
You also have 5 minutes.
Thank you.
The next case is Gorelick versus Cushman and Wakefield for the appellant.
Good afternoon, Your Honor. Robert Tucker for the defendant appellant Cushman and Wakefield.
You have 5 minutes. And the respondent?
Barry Fertel, attorney for the plaintiff, respondent, cross appellant. I'm here. Good afternoon.
Good afternoon. You also have 5 minutes. The next case is People versus Shore, which is submitted. We then have Moore versus Beautiful Spaces for the appellant.
Good afternoon, Your Honor. Scott Horn for the appellant.
You have 5 minutes.
Thank you, Your Honor.
For the respondent?
Carol Ann Herlihy for the respondent.
You also have 5 minutes.
Thank you.
The next case is Tracy versus Inspired Events for the appellant.
Gregory Generelli, Kenneth Reddy, Name and Associates. Good afternoon, Your Honor.
Good afternoon. You have 6 minutes. For the respondent, Inspired Events.
Good afternoon, Judge. David Schultz from Barry, McTiernan and Moore.
Okay, you have 3 minutes. For the respondents, Microsoft and Marriott.
Good afternoon, Your Honor. Allison Sherry of Davis Wright Tremaine for defendants, respondents, Microsoft and Marriott.
Okay, you also have 3 minutes. For the respondent, work in progress.
Yes, good afternoon, Your Honor. This is Mark Aladort from the law firm of Lewis Joes Avalon Aviles for respondent works in progress.
You have 3 minutes, and I don't know yet whether the other respondent for Ports America has been able to get online yet. Are you present? Okay, we'll go on with the calendar. Hopefully, he will be able to be present. If not, though, I know that you have similar positions with each other. So, okay, the next case is Russell versus New York City Fire Pension.
This is Phil Seelig from Seelig Law Offices for a petitioner appellant.
Okay, you have 4 minutes for respondent.
This is Claiborne Henry on behalf of the New York City Fire Pension Fund.
You also have 4 minutes. 186 Norfolk versus Uvin for the appellant.
This is Jonathan Wallace for appellant.
You have 6 minutes, and for the respondent.
Yes, Your Honor. Good afternoon. Philip Ortel, Rose and Rose for the respondent.
You have 6 minutes.
Thank you.
Muniz versus Shimienti for the appellant.
Right, he was here. This is the Nicole Kilberg for the respondent cross appellant.
Okay, so hopefully he'll be back in time for the argument, and you're here for the respondent. You have 4 minutes.
Your Honor, Eric Leiter, Moore Lilly Naparty for the respondent. It's a respondent appellant.
Okay, you have 4 minutes.
Thank you.
And Sheborn versus SR 677 is submitted, and Han versus Bright House is submitted, and that completes our call of the calendar. Counsel, please do not speak when a justice is speaking. And I reminded you earlier, please mute your microphone when you are not speaking. Please do not speak when a justice is speaking. This is especially important during oral arguments so we can hear everybody. And I thank you in advance for your cooperation. The first case being argued is People versus Brown. You can go ahead.
Good afternoon, Your Honors. My name is Jenna Weinblatt, and I represent the appellant, Jim Brown. Mr. Brown did not commit burglary because he did not know the police saw him enter his neighbor's apartment and therefore could not have intended to resist arrest inside. The only thing he could have intended to do inside was hide. In Cabino, this court held that even though the defendant was chased
Counsel, Justice Moulton, I'm sorry to interrupt you. Isn't the focus on his mens rea and what he thought and what he told people he thought was that the police were there to execute a warrant for his arrest. So it doesn't matter that they weren't, the police officers who actually knocked on the door. It's his intent that's important in determining burglary second. Correct?
You're correct that it's his intent that matters. And more importantly, it's his intent at the time he entered his neighbor's apartment. At that time, he did not know the police saw him enter that apartment and was only entering in order to hide. This court held in Cabino that passively.
Counsel, this is Judge Owing, but you know the efforts he went to hide are extreme. He swung off a balcony into a neighbor's apartment. It's kind of extreme if he wanted to hide. I mean, it seems like it's the intent there in his mind that he's looking to escape. Correct?
Your Honor,
he do a lot that he kind of catapulted off a terrace into another terrace. That's pretty extreme.
In Cabino, the defendant was told by the tenant of an apartment he unlawfully entered that he was going to call the police. He went up to the roof of a building, down a fire escape, jumped off a fence, was chased by police into a building, and this court still found that once he entered the building, his intent was only to passively hide from police, which was not a crime under
what's the significance that in People versus Cabino, there was absolutely no discussion of the resisting arrest issue and no analysis of that issue in that case? What significance does that have for this case?
Your Honor, that shows how strange it is here that we're dealing with in a resisting arrest statute. There was no discussion of that because it simply wasn't an issue. If the police are not effectuating an arrest, as they weren't in that case and as they weren't here, then the defendant cannot resist arrest.
But again, counsel, the focus is on his intent, not on the, in other words, his mens rea, not on the actus reus. Even if the cops were not there to effect an arrest, that doesn't matter. It's just what his intent was, what the defendant's intent was in absconding from his apartment.
Your Honor, the intent that matters isn't the intent he had when he left his own apartment. It's what he intended to do inside of his neighbor's apartment. The burglary statute has therein language. If he did not intend to resist arrest inside of his neighbor's apartment, it doesn't matter even that he tried to avoid police at all.
He asked his neighbor not to open the door for the police.
That was when he entered the apartment. He didn't know the police would come into his neighbor's apartment. That he may have formed some intent to resist arrest after entering the apartment is beside the point, because his intent that matters is the intent at the time he entered his neighbor's apartment. At that point,
Counsel, this is Judge Ryan. This is just the apartment that he was in that he left. Was that his apartment or was that the woman's apartment?
that was his apartment, but that's besides the point.
It was his apartment. Okay.
Yes, Your Honor. What matters is his intent at the time he enters his neighbor's apartment. And even in
we're going to have rebuttal time to respond. Let me hear now from respondent.
Thank you, Your Honor. Philip Tisney for the people. In this case, the defendant said not once or twice, but 3 times that his intent in going into the apartment, below the apartment where the officers had come to arrest him, was to avoid getting arrested. It was direct evidence that he intended to try to prevent that arrest.
Counsel, this is Judge Singh. Counsel, this is Judge Singh. How do you respond to your adversary that somehow the intent changed once he took the sheet and entered the apartment below?
I don't think there's any daylight between his intent to avoid getting arrested and his intent once he's in the apartment to avoid getting arrested. The intent remains trying to prevent the officers from affecting his arrest. That's why.
Because what did he do? What did he do once once the neighbor essentially said no to him? What did he do after that?
Well, at that point, he takes off again out of the apartment and falls to the ground. I'll say the appellant is correct that it's not his intent once he's in the apartment that matters. It's once what his intent is as he's walking in the apartment. But what he does in the apartment certainly reflects, or at least can reflect, on his intent when he walked into the apartment. And telling the resident, the occupant of the apartment, don't let the police in because they're chasing me, sort of further confirms what he said under oath to the grand jury, which was, I went into the apartment. I mean, he literally said, I walked into the apartment because I was trying to get arrested, or trying to avoid getting arrested. I mean, it's hard to conceive of more direct evidence of a defendant's intent to commit the crime of resisting arrest than a sworn admission like that in the grand jury. I'll just say briefly on Cubino, the significance of the fact that the court didn't talk about resisting arrest is simply that nobody there argued resisting arrest. We weren't as careful probably in our brief as we should have been. We said there was no evidence of that the defendant knew the police were chasing him. I think what's more accurate really is that there wasn't evidence beyond a reasonable doubt that he knew that the police were chasing him. The people there didn't argue resisting arrest as the predicate for the burglary conviction, and even conceded that they wouldn't have been able to make out resisting arrest. And that's critical because Cubino at the end doesn't say anything about what resisting arrest is. I mean, the people in that case argued the obstructing governmental administration charge, not resisting arrest. So it's really beside the point here. The last point I'll make is about the charge down. Again, the only way he would have been entitled to a charge down is if there was some rational basis for the jury to think that he was lying on 3 separate occasions when he told who he was speaking to that he wasn't trying to avoid getting arrested. You know, just as the court said, there was no basis for them to disregard those statements, and so there wasn't any real ground to give the lesser included. Unless the panel have any questions, we'd ask that you affirm the conviction.
Thank you very much. And there's 1 minute of rebuttal time.
Your Honor, the jury asked the court whether evading police is a crime. Clearly, if they had to ask that question, the very deciding factor in whether Mr. Brown committed a trespass or a burglary, they were unsure, and there should have been a jury charge on the crime of trespass. The trial court's refusal to charge the jury with trespass violated due process and warrants ordering a new trial. In any case, the charge should be vacated because, as this court held in Cabino, passively hiding from the police is not a crime. His statements inside of his own apartment just show that he wanted to avoid police in that apartment. He told Officer Bernard that he left that apartment in hopes that the police wouldn't see him at all. He was trying to avoid seeing the police, and the police couldn't arrest him if they didn't even see him. So he couldn't have possibly been trying to resist arrest inside of his neighbor's apartment. This is a clear case of trespass and overreaching on the part of the prosecution. We respectfully request that the court vacate and dismiss Mr. Brown's conviction. In the alternative, we ask that the conviction be vacated and the matter remanded for further proceedings. Thank you.
Thank you very much. The next case is Fuse Spirits versus UB Distributors.
Good afternoon, Your Honor. William Buckley for Fuse Spirits, the appellant. It's my privilege to introduce Mr. Michael Fawaz, who will argue for us from the firm of Howard & Howard in Michigan and Illinois.
Thank you, Your Honor. Thank you. Michael Fawaz from Howard & Howard, appearing for plaintiff appellant Fuse Spirits. Your Honors, I'd like to address a couple of issues today. The first is Supreme Court committed a procedural error where the court converted a motion to dismiss.
Counsel, this is Judge Singh. Did, in fact, your client request that the matter be treated as one for summary judgment? That's one question. The second question is even if it's incorrect, aren't we ultimately dealing with issues of law?
Your Honor, you are correct that Fuse Spirits made the request for conversion, but it did so in order to address a factual issue, the intent of the parties as to contract duration. It is uncontested that the contract at issue had no express durational term. It's silent as to that.
But does that make that a contract of indefinite duration under our case law?
It does, Your Honor, because the only means provided by the contract for termination are if the contract was terminated by mutual assent, bankruptcy, fraud, or a breach by one of the parties. Your Honors, every contract in the state of New York and outside of the state of New York can be terminated for the exact same reasons, whether those reasons are expressed or not in the contract. There's decisions.
Judge Kern, doesn't this agreement have very specific grounds for when the contract can be terminated? And why then should we allow any parole evidence to vary those very specific terms?
But Your Honor, those very specific terms, as one court that we cited described them, they're mere surplusage. They're meaningless because literally every contract can be terminated for fraud. Every contract can be terminated by mutual assent. The parties don't have to contract to those things. Those are meaningless grounds for termination because you could do those whether you agree to them in the contract or not.
Counsel, this is Judge Owen. Those are not superfluous and they're not verbiage. We have tons of cases, appeals cases involving those exact terms in terms of events of default and everything. They're there for a reason so that it doesn't make that this contract, because they have these sort of quote unquote, standard language in there that we should ignore them and say that this is a contract that goes on forever. That's not. I don't think we can just cast them aside. These are not verbiage. There's tons of appeals. Otherwise, we lose half our docket if we would agree with you.
Your Honor, what I meant by that is let's assume those four provisions, the fraud, the bankruptcy, the mutual assent, didn't exist in this contract. They just weren't listed. Could the parties still decide to terminate by mutual assent? Well, the answer is unambiguously yes. Could one of the parties cancel the contract if the other breached? That's been contract law for centuries. So there's superfluous provisions in that respect. There is no provision that actually provides for duration. And what I'm looking at, Your Honor, is the Haynes decision from the New York Court of Appeals, where they indicated that the weight of authority supports the related rule that where the parties have not clearly expressed the duration of the contract, the courts will imply that they are intended to perform for a reasonable time.
So this is Judge Kern. The real issue is whether or not it's a contract in perpetuity. And because it has specific terms, doesn't that therefore make it a contract which is not in perpetuity?
Well, no, Your Honor, because those specific terms, as I suggested, inure to the benefit of every contract, whether stated or not. You could terminate on those grounds anytime you want. I mean, for example, Your Honor, what the Supreme Court relied upon was a case saying you can terminate at the happening of an event. We don't disagree with that. You can have a contract that goes on until the happening of an event. But those contracts that go on until the happening of an event have that event enumerated. And here, what is the so-called enumerated event? You can terminate if you both want to. You can terminate if one of you breaches. Well, that's true whether that's stated or not. Every contract can be terminated under those grounds. In the United Chemical case that the Supreme Court relied upon almost exclusively said, you can terminate, and the happening of the event is if the defendant corporation ceases to exist. Well, yes, so is true if an individual to a contract dies. But you don't put those in a contract and suddenly say that is the happening an event. You need a specific event. And the best example of that, Your Honors, is I would implore the court to look at the North Shore bottling case, which was cited by the Supreme Court in passing. And the judge cited it for the principle that—
Justice Singh, do you have a question?
No, go ahead. Go ahead. I'm fine.
Okay, you have some rebuttal time which you can address that case in. So let's hear from respondent then.
Thank you, Your Honor.
Good afternoon, may it please the court. Joshua Siegel on behalf of defendant respondent UB Distributors LLC. The court need go no further than looking at Section 2 of the distribution agreement to affirm the Supreme Court. The distribution agreement is a valid contract. It's supported by consideration. There's no claim that UB Distributors breached the contract or defaulted. And Section 2.1, which is page 43 of the record, addresses the contract's term. And my brother argues that all of the grounds for termination are mere surplusage. They're not. Certainly, contracts can be terminated because of breach or if parties agree, but there are other possibilities here. There's bankruptcy or illiquidity going on for 90+ days. That's not grounds to terminate a contract under common law or other law. Discontinuation of normal service for 60 days. Any fraud, not just fraud in the inducement, as determined by a court. These are all other grounds that can exist that can terminate the contract. But the real one is—
Counsel, this is Judge Owing. Then my question then is that it seems that I hear what you're saying, that these provisions in here means that this is not a contract in perpetuity, but it strikes me that one side has to commit a breach or default to actually get this contract to end. And that in itself, for that party that does default or breach, that brings on a host of damages and everything just to get out of the contract. So don't you think that cuts against your argument that it is not in perpetuity? And essentially it is, because you're forcing the party, well, actually you're making it that the party has to behave themselves, right?
Yes, Your Honor. The contract is certainly written and was agreed by both parties, both sophisticated corporate entities, to go on for a long time and to continue to exist so long as the parties were performing under it. But there are events that can occur that will allow a party to terminate it. It's not easy to terminate.
Yeah, but those events are negative in a sense that they require negative or how we say not good conduct behavior, you know, right? It's not like somebody that's in a good place that can terminate the contract. You got to do something bad to have it terminated, which brings in, like I said, brings in damages to that side. So it's not a clean break in a sense.
I think that's right. I think that the parties were intended that. I think that was the intent of the parties, and that's apparent from the contract. And it makes sense if we look at the industry, Your Honor, because in the alcoholic beverage industry, the way that this is set up by statute is that Few Spirits is required as a distiller in a foreign state
required to hire a wholesaler in New York to sell the products to retailers in New York. And it is then UB Distributors, the wholesaler, that promised to develop marketing programs and maintain a reasonable inventory and build the goodwill of Fuse Spirits. And it's only with those assurances that Fuse Spirits cannot walk away at a moment's notice that UB was willing to enter into this contract. And Fuse Spirits agreed. They certainly were entitled to attempt to negotiate other terms. They were certainly entitled to go with other wholesalers or distributors who had more favorable terms. They didn't. They entered into this contract with UB Distributors. The contract is clear on its face as to what the
Counsel, this is Judge Singh, and your adversary, I'm going to ask him about United Chemicals in his response. What is your position with respect to the United Chemicals case?
Your Honor, our position is that United Chemicals is still good law. It is still the law of this department, and that the contract there was I guess even looser than the one. I don't know if loose is the right term. It was even broader than the instant one. There was no grounds for termination written into the contract there at all, if I recall correctly. The court described the contract as effective until and unless abrogated, canceled, and annulled by the consent of both the parties there too. And yet it was still enforceable. This court held that it was enforceable, and because it was not indefinite, because either side could cease doing business without other liability. And so if Fuse Spirits decides they don't want to sell spirits anymore and go out of business, then they can terminate the contract here without liability. Similarly, if Union Beer, UB Distributors, excuse me, their trade name is Union Beer, goes out of business or ceases operations, Fuse Spirits can terminate the contract as well, and the contract is terminated at that point.
Thank you very much for your argument, and there's 1 minute of rebuttal time.
Thank you.
Thank you, Your Honors. And I would like to start by addressing the points raised by Justice Oing here. I mean, we just heard it from counsel at the end. If you want to end this contract, we'll just cease to exist. Stop selling. Stop making products.
No, counsel. Counsel, I'm going to turn this around now, so that this is a commercial contract. The entities involved here are commercial businesses, correct? So that there's no such thing as there's no such thing as there can never be an end. It's called negotiating some sort of buyout, right? I mean, this contract doesn't prevent you from doing that, correct? I mean, you can get together and try to figure this out. Yet you just can't leave without, you can't just leave and just leave. There's always negotiation points. And why should the court get involved in a commercial case like this where you guys can figure this all out, right?
Well, respectfully, Your Honor, the court should get involved because it is an implied perpetuity. I mean, the argument here was you can cease to exist, but that was actually the whole holding of the United Chemical case. And I submit to you
I'm just saying that if I don't, I'm just saying, assuming we don't agree with you, you're not stuck to this contract forever. You can negotiate. There's always a negotiating technique. I mean, this is a business. Right.
But Your Honor, you're suggesting negotiating, which I think by its very nature is, can the parties try to negotiate short of terminating the contract? I mean, it says you can end it by mutual assent, which you can do with any contract.
So let me stop you there, counsel. This is Judge Singh, and I just want you to respond to the United Chemical case. Why is United Chemical not good law? Because in United Chemical, it was just termination by mutual consent, and that was found sufficient. Now, it's an old case, I acknowledge. Why is it not good law?
Well, actually, Your Honor, the United Chem case was not mutual termination. The idea behind it was what the holding was, that if you want to terminate it, the happening an event can do that, and the event would be the end of the corporate defendant, the defendant ceasing to exist. And I think that goes to the idea that Justice Oing was hitting on, which was just, it's all negative. You either have to cease to exist or commit fraud or breach the contract to get out of the contract. And that is implied perpetuity. It is not express agreement. And again, I want to turn.
Thank you very much for your argument. Your time is up.
Thank you, Your Honor.
Our next case is Michelle versus Luke. Appellant?
Yes. Jason Advocate for the appellant, Luke R. May it please the court. At the outset, I would like to make clear that the only challenge in this case is to the duration of an order of protection. The appellant here has acknowledged throughout this case and before that what he did was wrong, that it was absolutely inappropriate conduct, and he's accepted much of the consequences.
What are there aggravating circumstances in this case which would justify imposing a 5-year order of protection?
Your Honor, there really are no aggravating circumstances here. It's acknowledged by all the parties that the first 4 subdivisions of FCA 827 just do not apply in this situation. And the court relied on the 5th, the catch-all, that says that if a party presents an immediate danger to the petitioner, that there's a ground.
Throwing liquid on her constitute an immediate danger?
No, Judge, and that actually wasn't what the underlying court was saying. The underlying court wasn't saying that the actions of my client, certainly wrongful, absolutely appropriate for an order of protection. No one was contesting that, but the judge didn't say that was the basis for the 5-year order of protection. What the judge was saying was, at the trial, during his examination by the petitioner's counsel, he was hostile. He showed a bad demeanor.
So he wasn't just hostile. He was implying that he should have gotten an apology from the victim.
Judge, I do think,
and he engaged in a great deal of harassing behavior over the phone, including impersonating the victim's mother. So why isn't that enough to show aggravating circumstances?
Well, the aggravating circumstances in sections 1 through 4 require more than that. Okay, there's a higher standard, and all the cases have a higher standard here. No one here is arguing that what he did was permissible or allowable. That's absolutely not the question here. But in the cases, for instance, Monware is a case cited regularly, and it's cited in the briefs. There was a pattern of both physical and sexual abuse. Harry, a case cited by Harry v. Harry, a case cited by both the parties in this case in their respective briefs. There was knives were threatened and used against the petitioner in that case. Riley, there were multiple violent, harassing behaviors. Violence is key. Something more than simply throwing a noxious substance, which was absolutely wrong, on the petitioner here. It caused her certainly to be afraid at the time. It didn't cause her physical injury.
You're not saying that he gets one free slap or punch, right? You're not saying that he has to commit.
Oh, of course not. No. What he did was wrong, and it absolutely justified an order of protection. From the start, he was saying, I will take the punishment. I believe a 2-year order of protection. That's the standard length of time for the longest you get without the aggravating circumstances. That's fine. But a 5-year order of protection, she will have.
So, counsel, it's your position that as my colleague laid out, there was a pattern of hostile acts by telephone, et cetera, is not something that family court could consider in determining the length of the order of protection?
Well, Judge, first of all, with respect to the pattern, there wasn't really much of a pattern here. The client
did he? Okay, let me stop you there. Did he pretend to be calling from the mother's phone?
Yes, he did, Your Honor. And it's something called spoofing. He was trying to get. He had a relationship with the petitioner for months. When he had come back from vacation, there was absolutely no contact. And he just didn't know at that time, as he testified to, whether she was alive or dead. So at that point, he called her, and that was the last time he called her. He did, in fact, though, there was text messages exchanged after that.
Counsel, do any of the justices have any more questions for counsel? Okay, let me hear from opposing counsel then.
Thank you, Your Honor. Sergio Villaverde, the law offices of Sergio Villaverde. May it please the court. I must disagree, as may be expected, with my distinguished colleague on a couple of key points. The court, if you look at the record at page 22, the decision of Justice Dawson, one of the senior IDB justices in New York City, said that the aggravating circumstances finding is based on the testimony as well as the evidence witness testimony. However, your honors are correct. There was a pattern of behavior. He pled guilty to aggravated harassment in the criminal matter in this, and he was allocated, and that is also on the record of this court. However, what was left out of the presentation by my esteemed colleague was his behavior also at trial, where he felt that he was the one who was aggrieved. Page 22 of the record, it's page 18 of Judge Dawson's decision. Specifically, respondent's hostility and aggressive demeanor at trial, where he appeared defensive and angry while glaring at my client, I'll leave her name out, and in attempting to portray her as partially to blame, maintaining his entitlement to an apology, demonstrated that he remains an immediate and ongoing danger to the petitioner. This is something that the trier of fact sees. As your honors are all prior trial court attorneys, you know what is in there, the glare, the seething that comes from a respondent makes a difference in determining, is he an immediate and ongoing danger? Is that section of what aggravating circumstances qualify for met? And we respectfully submitted to the court that it is. And the court found—
Address your cross appeal?
Yes, ma'am, thank you. We agreed with the court we agreed with the lower court that they do not have to, as a matter of procedure, always have a dispositional hearing. The dispositional hearing in this, with respect to the order of protection, even with respect to the aggravated circumstances, the jurist can make a determination on her own as to what she thinks the disposition should be. However, in this case, my client was clearly victimized by the gentleman. The statute calls for counsel fees that can be obtained upon a finding.
Was your cross appeal, was it timely perfected?
Yes, Your Honor, we received an extension.
Give me the dates that you say why you believe it was timely perfected. Because it looks like to me that it wasn't, so I do want to look at that.
There was an order from the court, Your Honor. I apologize. We were on for the cross appeal, so I didn't have that handy. It will take me a couple of minutes to get to that, Your Honor.
So you're saying the date of the order of the court, I can determine that. So date of the order of the court. And how did you perfect timely?
We received an enlargement of time, Your Honor. That's the mechanism by which we perfect.
Did you receive an enlargement of time from us by motion? Yep. You made a motion? Okay, and then what did the order say in terms of how much time you had?
It said, one moment, Your Honor. I apologize. I was not prepared on the procedural aspect as I was on the substantive. There is a decision that is dated September 3rd, 2020. An appeal having been taken to this court by respondent appellant. Respondent from an order of Supreme Court, New York County, IDV part, entered on or about May 13, 2019, and from an order of protection of the same court, entered May 13, 2019. The appeal having been perfected, and the petitioner, respondent, appellant having moved for an order enlarging. One second, Judge.
You have the record, then we can look at it.
Yeah, we'll look it up ourselves. That's okay, counsel.
Thank you very much.
Judge, I would like to just briefly finish on the point of the counsel fees.
Time is up. Very quickly wrap up.
Yeah, I will very quickly wrap up, Your Honor. That there is no way for a litigant to ask for counsel fees until there's a finding of the family offense. So the procedural cart was put before the horse by the lower court, and it resulted in a further injustice to this petitioner in the lower court. I thank the court for its time.
Thank you. The next case is Belfon versus Petosa. Let's hear from the appellant.
Good afternoon, Your Honor. May it please the court, Dean Pillarella for defendants appellants. In Treppel, this court held that because the Arizona Board of Regents was an arm of the state of Arizona, and because Arizona had not consented to sue to New York's courts, Hyatt required dismissal of the action against the board and its employee for lack of subject matter jurisdiction. This case is fundamentally the same. Respondent concedes that transit is an arm of the state of New Jersey and that Mr. Petosa was acting in the course of his official duties and within the scope of his employment at the time of
Counselor,
accident.
can I stop you there for a second?
Yes, Your Honor.
I understand very well the argument with respect to the state, but with respect to the bus driver, I understand that, that in your brief you argue that he was acting in the scope of his authority and therefore he should get the same immunity. But isn't, under New York law, isn't a bus driver individually, or a driver of a vehicle jointly and severally liable? In other words, he is individually liable for his or her actions in having an accident.
Your Honor, I believe there certainly is a distinction between a claim against a state official and his official as opposed to individual capacity. But as I read Treppel, in that case, the state employee was a professor who had engaged in the carbon dating. The court didn't make any distinction.
Yeah, but this is a car accident. We have very particular rules with car accidents, don't we, in this state, in terms of how we treat joint and several liability with respect to automobile accidents?
Yes, certainly, Your Honor. Well, I would note that in the Morrison versus Budget Rent-A-Car case, the Second Department held that South Carolina officials who had gotten into a car accident in New York were subject to sovereign immunity defenses. Now, that was under the Nevada versus Hall paradigm, but the Second Department did still hold that the sovereign immunity defenses were applicable. If I could return to the question of a waiver, pursuant to the Supreme Court's decision in Edelman and College Savings Bank, a waiver must be express and unambiguous.
Counsel, this is Judge Owing. This is Judge Owing. And talking about the waiver, with the Hyatt decision, Supreme Court's decision now basically said that sovereign immunity is absolute. There's no permissiveness anymore, right? You need to have express consent. Don't you think that's kind of unworkable? Don't you think that's kind of unworkable when we're dealing with crossing interstate with transportation situation? Because if you think about it, and practically speaking, are we suggesting that New York is going to tell all the New Jersey transit buses to stop at the crossings and say, unless you expressly waive your right to be sued, you're not coming in? That strikes me as just it doesn't make any sense, right?
Well, Your Honor, I would note that there are cases, for example, in the Third and Fourth Department, where arms of tribes, in the tribal immunity context, you'll have a tribe engaging in commercial activities, sometimes in a car accident or operating a hotel, and the Third and Fourth Department sometimes will hold in cases that simply because they're engaging in a commercial activity within New York State, that doesn't necessarily mean that there's no sovereign immunity applicable. Again, the standard is simply whether or not there's a waiver, express and unambiguous waiver. With respect to questions of public policy and workability, I believe that the Hyatt majority addressed these concerns by responding to the dissent's contention that when a private citizen sues one state in the courts of another, both states have strong sovereignty-based interests. I believe that the majority simply rendered questions of policy irrelevant. In this case, New Jersey hasn't consented to suits in New York, either through the New Jersey Public Transportation Act of 1979, that's Transit's Enabling Statute, and certainly not
Counsel,
the New Jersey
Judge Singh, let me stop you there for a second. If we were to agree with your position and dismiss the case, what would happen? Does the plaintiff have redress? Does the plaintiff have the right, because statute of limitations has obviously expired, does the plaintiff have the right to sue in New Jersey, or would you stipulate that you wouldn't raise a statute of limitations defense?
Well, that would be a matter. Well, that would be a matter for a New Jersey court to decide. I believe the way it works.
So in other words, what you're telling me is you wouldn't stipulate to it. So you would non-suit the plaintiff in these circumstances, and let the courts in New Jersey decide whether or not there's some sort of saving statute, or whether the statute of limitations somehow didn't expire. Is that correct?
I'm not sure how I would deal with it. What I know is that Section 59.8-8 of the NJTCA says that all suits not commenced within 2 years will be forever barred. So that would be for a New Jersey court to determine whether or not a plaintiff could perhaps commence a special proceeding to seek late commencement.
Counsel,
now there's an insurance policy here, I assume, right? You're a carrier. You're a carrier. It's the carrier defender, right? In this case, am I correct about that?
No, you're.
I'm not.
No.
There's also, so New Jersey is self-insured, is that right?
Yes, and sometimes it depends on a case-by-case basis, but as I understand, yes.
Counsel, this is Judge Owen. I got a real narrow question with respect to the bus driver.
Yes.
What if he doesn't fall into a qualified immunity and that he can be held individually liable? Is he out on his own, or is there some sort of remedy that he may have with respect to the state indemnifying him?
I believe the state would still be obligated to indemnify him if Your Honors found the suit to be against him in his individual as opposed to official capacity. I contend that the suit is against him in his official capacity. Certainly at page 15 of Respondent's brief, he argues that Mr. Petosa was engaging in quote unquote business activities for transit. Certainly at pages 78, 79 of the record.
But again, counsel, can't a driver of a motor vehicle be liable under two separate circumstances? Individually responsible for his actions, as well as jointly liable, where then the state or the owner of the vehicle, for example, would also be liable.
I certainly agree with Your Honor that there is a distinction between a suit against an individual and in an official as opposed to an individual capacity. I would just again refer the court to the Morrison budget case of the Second Department. And I also cite in my briefs, I cite a appellate court of Connecticut case that dismissed case. That
was the Rhode Island case, but that's a different circumstance. The cases I'm interested in are the motor vehicle cases because, as my colleague points out, this rule of sovereign immunity does sort of run amok how we traditionally look at these kinds of cases.
Your Honor, I'm not aware if there have been any motor vehicle cases dismissed on the basis of Hyatt. I point out in a footnote in my brief that I believe the Attorney General of Indiana raised in an amicus brief the fact that it had been subject to suits for a car accident case in Ohio's courts. I don't know how that played out, but I would again.
Counsel now. Thank you. You have rebuttal time.
Thank you, Your Honor. Thank you.
Counsel, are you there?
Oh, can you hear me? Howard Cohen for the plaintiff respondent. Good afternoon, Your Honors.
Yes, we can hear you.
I believe that the exercise of jurisdiction in this case would not violate the holding of the U.S. Supreme Court in Hyatt, nor would it infringe on the sovereignty of the state of New Jersey. The two cases, Hyatt and this case, are totally distinguishable. Very briefly, I'm sure the court is aware that Hyatt involved a suit in Nevada state courts against a California state entity that had sovereign immunity under California law. It arose out of a California audit to determine whether—
Counsel, this is Judge Owen. I would tend to agree with you, and I thought there could be a distinguishing factor because Hall's facts involved the motor vehicle and Hyatt involved exactly what you said. The California, the auditors, the tax board. The only problem is that in Hyatt, the tax board agents actually physically entered Nevada and prosecuted and went after Mr. Hyatt. And that's where I thought, okay, there's the problem right there.
Well, except what they did was, as I recall, they took a couple of statements in the state of Nevada, but the audit itself was conducted in California.
No, they didn't take only a statement. According to the Supreme Court's fact analysis, they also disseminated some not so nice things about Mr. Hyatt, which is where the link or the hook of the tortious conduct comes from. I mean, I'm sympathetic to you, and I want to make sure that Hyatt could be squared on all fours, and unfortunately, they physically entered Nevada.
Well, I believe there are additional distinctions. As you see, first of all, let
me ask you something before you go on with that. Because the language in Hyatt is much broader than the actual holding of the case. It says in all cases, the sovereign immunity. It's not really based on the particular facts of that case. It says the state has sovereign immunity unless there's an explicit waiver. So how do you get around that very broad language in the Hyatt case?
I'd say two things. In terms of sovereign immunity, New Jersey Transit is an arm of the state of New Jersey. We don't contest that. New Jersey law, unlike the situation in the Hyatt case where the agency has sovereign immunity, New Jersey Transit in its own state does not have sovereign immunity. It can be sued by New Jersey
The legal question before us, which we have to answer, is whether it has sovereign immunity in this state, not whether a sovereign immunity in that state. The distinction you want to make, I see articulated in Hyatt anyway.
Well, what I said about New Jersey Transit not having sovereign immunity is only the first step, because the defendants at first alleged that they did. They concede they could be sued in New Jersey, but we're not alleging that the New Jersey Tort Claims Act is the basis for this court's jurisdiction. What we have here is a situation where New Jersey Transit voluntarily entered the state of New York. That New Jersey state agency elected to enter the state of New York, elected to conduct business activities in the state of New York. One of its vehicles was involved in an accident in the state of
Can you address the issue of jurisdiction over the driver individually as opposed to jurisdiction over New Jersey?
The driver was a driver of a vehicle, as in any other case. He's responsible for his own actions. He may, whether he was acting as an employee, he was still the driver of a vehicle. So that would not insulate him from liability. And the defendants speak about New Jersey sovereignty. What about New York sovereignty? For the reasons I stated, I don't believe because the New Jersey agency elected to come into this state, it would infringe on New Jersey sovereignty to enter this suit. But on the other hand, if the
Supreme Court doesn't agree with you.
But what about New York sovereignty? If New York cannot entertain a suit under these circumstances, I believe that would be an infringement.
Mr. Cohen, this is Judge Joyner.
New York sovereignty. Yes, Your Honor.
This is Judge Joyner. That goes back to what I said. You have to stop everybody at the crossings and say, yeah, sign this waiver, otherwise don't come in, and turn around.
I mean, or elect not to come into the state in the first instance, but they elected to do that. I mean, as I said, I don't mean to beat a dead horse.
But I hear what you're saying, but you know, this Hyatt decision transformed what was before Hyatt a permissive sovereign immunity defense to an absolute sovereign immunity defense. I mean, the court went on to say it doesn't matter what the sovereign does in its own state. The sovereign can do whatever it wants in its own state, but another state cannot sue, cannot hold or hail that sovereign into the forum state. It's the most glaring and incredible statement that the court said.
The way I would look at it, Your Honor, is that the state of California elected to give its agency, which was the defendant in its action, sovereign immunity under its law. In this case, New Jersey did not elect to give New Jersey.
But Mr. Cohen, Hyatt says that's irrelevant. What the sovereign does within their boundary, within their borders, is irrelevant to the analysis of whether or not sovereign immunity is provided to that state to another state. I thought about the same thing. Why is it if the sovereign doesn't give immunity to its own people in its own state or its own borders, that it should also be held accountable in another state? And the Supreme Court in Hyatt said, doesn't work that way.
If I can answer that with a rhetorical question.
Thank you for your argument. You have 1 minute of rebuttal time, Mr. Pinarello.
Thank you, Your Honor. With respect to the individual versus official capacity, I would just note that argument was never raised by the respondent.
But didn't you raise it, counsel? You raised it in a footnote because you discussed a Third Circuit case, and you raised it. Now I understand your adversary didn't address it. You raised it, so why can't we consider it?
Well, that was a 1983
That's right.
case.
So you raised it. So you raised it in the sense, as I understood your argument from your brief, that the police officers acting in their official scope were entitled to sovereign immunity, but with respect to their individual capacity, it was a qualified immunity based on different grounds. So I'm not sure I agree with you that we can't consider it because it's an argument you raised. And there's another question I have for you, sir. The accident here was 2012, right? 2012. Yes. The U.S. Supreme Court came down with its decision 2019, some 7 years later.
Yes.
Do we apply the Supreme Court decision retroactively? It's not addressed in the brief, or is it prospective?
Oh, no, it's applied retroactively because that's how the Supreme Court applied it in Hyatt. It applied it retroactively. With respect to Justice Owing's considerations, what Hyatt really did was it restored the framers' notions of cooperative federalism. So the majority talks about how by consenting to the federal forum, a neutral federal forum under Article 3 of the Constitution, the states gave up their right to treat each other as legal strangers. So I would just like to point out that those concerns are raised and addressed by the majority in the Hyatt decision as a historical matter.
Have any more questions? Okay, let's go on to the next case. And thank you very much.
Thank you, Your Honor.
NYC Sale versus Appellate.
Yes. Good afternoon, Your Honors. My name is Michael Sucher. I represent Appellant, the Bethelite Church, a Harlem institution. I will discuss 3 reasons why the appeal should be granted and the judgment of foreclosure vacated. First, though standing is challenged by affirmative defense, the record is devoid of any proof of respondent trust's standing. Second, the interest rate of 18% reported by the referee and confirmed by the lower court is wrong as a matter of law. And this erroneous rate works a windfall to respondent of about $1.5 million and a ruinous detriment to appellant of the like amount. And third,
Judge Singh, with respect to the interest rate, doesn't the Administrative Code Section 11-328 provide for that? Or am I wrong in how I'm reading that provision?
I believe you're wrong in how you're reading it. It is the New York City Council on a year-by-year basis that determines the interest rate on delinquent, both tax rates and in this case, water and sewer rates. And it is the administrative code that says that a holder of or a purchaser of a tax lien, a holder of a certificate, is to be treated the same as the city, not better than the city. And here there is proof that for delinquent water and city sewer rates in the 2002 fiscal year, there was a 9% rate for parcels whose annual real estate tax is less than $2,750. The issue between the parties is the meaning of that phrase, whether it means the bill or it means something that might or could or would have been the tax had there been no charitable exemption or religious exemption as there is to this church.
Counsel, this is Judge Kern. Isn't there a waiver of the issue of your challenge to the 18% interest because it was never raised in opposing the referee confirmation?
I don't believe that it's a waiver, Your Honor. It's a pure question of law that this court, under at least the Vanship and its progeny of cases, can address because even if it wasn't
that time when you were required to raise any objection you had to any computation in the referee's report when there was a motion to confirm.
The problem with all of that, Your Honor, is that prior counsel raised it on summary judgment and the judge below sent it out to a referee, and the referee's submission was given ex parte, and that ex parte deprived the appellant at that point of even addressing it to the referee.
Wasn't there a motion to confirm?
You bet there was, Your Honor. There was a motion to confirm, and that motion to confirm, as Justice Kern rightly observed, the issue of the interest rate was addressed only in the most oblique way by other prior counsel. And I think that question of law is certainly preserved by this court because it is an issue. Had it been raised could not have been avoided. And it is something that can be determined as a matter of law, a pure question of law. And from the record in this case, this court can make that determination. The question, of course, is what is the interest rate that should be applied? And I think that the New York City Council resolution that is made every year indicates that for annual taxes that are less than $2,750.
Counsel, is that resolution before us, though? Is that even in the record?
Yes, it is also a public record that this court can take judicial notice of. We did put it was put in the summary judgment motion by the parties. So I can tell you that that is definitely in the record, although I don't know that I can put my finger on exactly where in the record it is. I think it's 727 of the record. And that is the city council does this every year for both delinquent taxes and water and sewer rates. And the interesting thing is that our position is that the statutory, the code section and the resolution language is not ambiguous at all, and that annual tax on a parcel is the annual tax that is billed. But if Your Honors, as a matter of law, determine that there is an ambiguity in the language, since certainly the respondent argues to the opposite, that doesn't make it ambiguous, of course, but it can lead to an ambiguity of understanding if two different people see things in different ways. The actual language on the tax certificate as parole evidence indicates that the drafter of the tax lien certificate itself used the words annual tax bill, not annual tax on a parcel. We've also inserted as a matter of public record that Your Honors could take judicial notice if you need some parole evidence on that question from the New York City hearings at its Department of Finance, at its Committee on Finance, the Council's Committee on Finance, where it was repeatedly used interchangeably, annual tax as the code language is, and annual tax bill as the members of that committee used interchangeably. And of course,
thank you very much for your argument. I'll now
Good afternoon, may it please the court. I'd just like to address first, as relates to the issue of interest, that the tax lien certificate was amended. At page 189 of the record, you'll find the amendment to tax lien certificate. The tax lien certificate shall contain the rate of interest that the tax lien certificate shall bear. That is the New York City Administrative Code, section 11-328. The tax lien certificate as amended does contain the interest rate that the tax lien certificate shall bear, and it explicitly states that interest shall accrue thereon from the applicable sale date at the rate of 18% per annum compounded daily. In order to plead a defect with the tax lien or the tax lien certificate, appellant needs to specifically plead and affirmatively establish a defect with the tax lien or the tax lien certificate pursuant to the code at section 11-336. The appellant does not specifically plead in the amended answer, which is at page 549 of the record. Appellant simply states in a conclusory fashion that the rate of interest isn't authorized by law. There is no mention to what law doesn't authorize the interest rate. There are no facts to support the allegation that the interest rate isn't authorized. And the defense not only doesn't comply with that section of the administrative code, but I'd argue that it doesn't comply with the pleading requirements of CPLR 3013. As relates to all this parole evidence proffered by the appellant, the record testimony from Common Counsel, he proceeds to just postulate and hypothesize about the meaning of certain resolutions and definitions and the words contained therein, but nothing in this record affirmatively establishes that the interest rate of 18% is incorrect. The tax lien certificate is controlling here. It is clear evidence that the intention of the council and the city of New York was that the rate of interest on this lien be 18%. Because he's neither specifically pled nor affirmatively established a defect, the court did hear the interest rate argument on summary judgment and decided to refer the matter to the referee for report and dismissed the defense as relates to interest rate. As far as the referee's report is concerned, respondents complied with the summary judgment order, and that's all that's required by HSBC Bank USA versus Simmons. It's a Second Department case from 2015 that states that in order to establish entitlement to judgment of foreclosure, all that the plaintiffs needed to do was comply with the order. granting summary judgment and present a fully executed referee's report. The plaintiffs did so. The summary judgment order is located at page 1006 of the record.
Also, the defendant complains about the referee not holding a hearing. Would you speak to that?
Sure. We can see that the referee did not hold a hearing. Respondent's position is that first, the summary judgment order did not require a hearing, but more importantly, that there was no prejudice suffered by the appellant by the referee's failure to hold a hearing. First of all, this court decided in Hartsfield versus City of New York Division of Real Property that the authority of the referee is only what is granted to the referee by the summary judgment order. Here,
Counsel, this is Judge Singh. Is your adversary correct that you sent documents to the referee ex parte and his client or the attorney did not receive those documents?
We sent documents to the referee. The referee computed without holding a hearing. A hearing was not.
Ma'am, I'm sorry. Would you just answer my question?
Yes.
Was it done ex parte?
Yes, the documents were sent to the referee and not to.
They were ex parte. Okay, thank you.
However, the fact that they were ex parte did not work a prejudice against the appellant because prior to confirmation of the referee's report, the appellant had full and fair opportunity to contest anything contained in the referee's report in opposition to the motion for judgment of foreclosure, the order of which is being appealed from here, and failed to do so. It's also our position that the referee was a court-appointed officer for the purposes only specified in the order of reference. The order of reference said that the referee was appointed to compute the amount due on the note and mortgage, which clearly this is not a mortgage foreclosure action, it's a tax lien foreclosure action. However, I would respectfully submit that a tax lien certificate is akin to a note and mortgage in that the tax lien certificate explicitly sets forth the amount of principal and interest. So the computations of the referee were simply to take the principal amount reflected on the tax lien certificate, which is presumed valid, take the interest rate reflected on the tax lien certificate, which is presumed valid, and do that math. The referee was not with the authority to do.
Thank you very much for your argument.
Thank you very much.
Okay. The next case is Union of Automotive Technicians versus Port Authority, and we'll hear from appellant.
Good afternoon, Your Honors. Craig Kozin on behalf of appellant. Your Honors, this case involves an issue of bargaining unit members' privacy and discipline as mandatorily negotiable terms and conditions of employment, as recognized by both the Port Authority Employment Relations Panel in the case of 95-8, that's 95 PA ERP 8, and also in the New York State case of the matter of Board of Education versus PERB. Being mandatorily negotiable terms and conditions.
Counsel, this is Judge Singh.
This is Judge Singh.
Isn't airport security a essential aspect of the Port Authority's operation of airports? And wouldn't that be outside the agreements here?
Well, Your Honor is absolutely correct. The appellant agrees that the Port Authority has an interest in maintaining security at the airports. The federal regulatory scheme permits the Port Authority to make a decision about who has access to secure areas and who does not, based upon a number of factors. One of them is the SIDA application, and the regulation is very specific with regard to what is to be included in the SIDA application and what is not. So yes, the Port Authority may make that decision, but that does not give them carte blanche to include in the SIDA application.
Didn't TSA ultimately, in a memo, update legal guidance with respect to the issue of what could be looked at?
They provided guidance, Justice Singh, with regard to the issue of what the Port Authority may look at. It may look at such things, and the appellant has recognized this in their brief, as an employee's behavior in a restricted area, etc. But from the standpoint of the application, they may look at the application, but the application is limited in its contents.
Counsel, why isn't this a qualification for employment, which would be outside the purview of collective bargaining?
There has been no evidence introduced by the employer, in this case, the Port Authority, that this is a job qualification. In fact, Your Honors, there is a memorandum of agreement in evidence in this case, and the job specification for each of the covered positions and within this bargaining unit are set forth at pages 39 to 60 of the memorandum of agreement. Council.
Is part of the qualification to have adequate security clearance? Isn't that a qualification for employment?
Not a job. I'm sorry, Your Honor. It is not a job qualification listed anywhere in any evidence or any document that I'm aware of. It didn't come in the record before the panel. And again, the memorandum of agreement establishes job specifications for bargaining unit members. Not a single one of them has cited clearance as a job qualification. So the council pointed out in their brief that we didn't contest that it's a job qualification.
What is what the Port Authority does, which is security? I mean, that is a central component of what the Port Authority is required to effectuate is security at the airport.
Yes,
to determine what is adequate security.
Yes, and I think, Your Honor, the panel didn't want to be the one to tell the Port Authority that it could not ask questions beyond those which are permitted in the regulation, because security is an overarching issue. And if we look at the hearing officer's report and recommendation, bottom of page 16, going on to page 17, both the hearing officer and the panel relied upon security. Of course, the Port Authority has an interest and a right to maintain security. That's a recognized interest. And the TSA recognizes this interest and circumscribes the means by which any airport operator may achieve the security. I'm sorry, Your Honor.
Regulations specifically provide that they can have different requirements? Isn't that explicit in the regulations?
And those requirements are the ones outside the application, because the regulations are very specific about what may and may not be in the application. So yes, the Port Authority may look at other things.
But it allows them to also use their own judgment and what to put in their own specific qualifications at the Port Authority.
I would say not inputting their own specific qualifications, Your Honor. Everything that we look at that says the Port Authority has a right to make a decision as to who has access and who doesn't is within the broader picture. Yes, the Port Authority has the right to make the decision. Part of what they make the decision on is the CITA application, but that does not mean that they can just blow the regulations out of the water and ask anything that they want to, when the regulations themselves say that the Port Authority may only ask these 28 questions regarding disqualifying crimes. The Port Authority admitted.
Thank you, Counsel, very much for your argument.
May I just add, unless I have rebuttal time, Your Honor?
Don't have rebuttal time.
May I just add two things very briefly? Your Honor, we don't believe that there's a need for a remand in the event of finding against the Port Authority. There's been a fully developed record in this case, and we submit that the Appellate Division can determine the issue as a matter of law.
Okay, thank you very much.
Thank you very much, Your Honor.
We'll now hear from Respondent Port Authority.
Good afternoon, Your Honors. This is Paulo Alves for the Port Authority Law Department. The issue before the panel was only whether a topic was negotiable or not. And the panel is authorized and has been making those determinations for half a century. They're entitled to deference on that determination, and they were correct for the following reasons. One, and this addresses UOAT's argument on the privacy and discipline as well, they found under their own precedent that having a CITA badge clearance is a job qualification. They also found under long settled precedent in panel law that job qualifications are not negotiable, they're not terms and conditions of employment. Using that precedent, they reasoned that the criteria and the standards to go into determining whether a person is qualified to work in secured areas is also non-negotiable. Now, that was after a full review of the record using their law and their expertise. And the inquiry really ends there because the determination is whether or not something is a negotiable subject in collective bargaining. And once there's no term and condition of employment, there is no duty to bargain, and there is no improper practice. I'm sorry, Your Honors, did someone? No, okay.
Just a little echo.
Okay, so the UOAT.
Counsel, this is Judge Singh. How do you respond to your adversary that the determination should be limited to what's provided in the CFR?
Well, the CFR is promulgated by the TSA under the guidance of under the umbrella of the Department of Homeland Security. And part of that responsibility is to issue guidance on how to administer this at the airport operator level. Now, the Port Authority has two roles. They have a hat as an airport operator, which applies to everyone in the airport. They also happen to be an employer. The role they're fulfilling here is as an airport operator, which is a non-delegable statutory responsibility to ensure security at the airport. And in following the guidelines, which is the pertinent pages are located in the record at 648 and 649, the TSA specifically advises that an airport operator or a granting official can use additional criteria other than those found in the regulations in order to make a determination as to suitability for a person that needs access, not an employee, but a person that needs access to secured areas. That means everybody. And they actually give an example. For example, they say a crime pops up that is 12 years old as opposed to 10 years old, like the CFR mandates. And you can look at that, the Port Authority can look at that and make a determination based on their own suitability needs because they operate specific airports that happen to be one of the airports under the highest threats in the nation. And they can make a determination, can this person access unescorted into the secure areas of the airport? And the reason for that is because it's not just a privilege, there are obligations attached to this. When a person has unescorted access to secured areas of the airport to do work or something else, they have the obligation to report things that they see that are suspicious or someone without a badge or whatever the situation is in order to ensure the safety as well. It's an added protection. In order for that to happen, there needs to be trust. And you have to understand the airport operator needs to know with a reasonable degree of certainty, obviously no one's ever certain, that this person is trustworthy and will report back and fulfill their obligations. The Port Authority has to submit an airport security program to the TSA for approval that includes these applications. They are approved, and then the Port Authority, as the operator, has to implement them. Nowhere in this statutory scheme or regulatory scheme, or even in the regular operational scheme, because this requirement to pass applications, disclosures, criminal history checks preceded the TSA guidelines, and the Port Authority still did that, fulfilled that function under their role as an airport operator, and the UOAT members, as testified below, for decades before the TSA was created and the regulations came into play, went through this process. It was never negotiated, never negotiated. And the reason for that is because, as the panel said, and they are able to do this, which is they've been doing it for a long time, is no, this is a job qualification, okay? And it's not discipline if you don't get the badge. What that is, and they citing to APA ERP 12, which they relied on in their decision, also dealt with the discipline aspect. There's a distinction between not being able to work because you've lost the qualification or difference between that and someone imposing a penalty on you to punish you for an offense.
Okay, thank you so much for your argument, counsel. I hope that Ms. Mitchell was able to get back on the line. Are you there, Ms.
Good
Mitchell?
afternoon. Can you hear me?
Yes.
Oh, great. So this is Ellen Mitchell. I'm attorney for respondent, Port Authority Employment Relations Panel. I have a couple of procedural and technical issues for the court that I need to put on the record, please. The first one is that, unfortunately, I have to alert you that review of our brief shows that there's a quote which miscites the panel's decision. The panel's decision is correctly cited at R 815, but the quote is incorrect. Again, that's panel's brief at page 24. We request that the italicized portion of that quote be disregarded, and we apologize for the mistake. We also note that the reply miscites the panel decision. If you compare reply page 2, they say they write managerial prerogative in quoting the panel decision, but the decision at page 9 simply says prerogative. Also, we need to note for the record that there are certain newly raised allegations contained in the appellant's reply, which should be rejected as they were not argued in appellant's petition or brief. Appellant argues for the first time in its reply that the panel erred in finding that the contents of the security application were not terms and conditions of employment. At reply page 1, they list that argument. You will not find it anywhere in the petition or appellant's brief. Reply also offers an argument for the first time that the panel erred in finding employee discipline is not a term and condition. That again is at reply page 1. Let's see, pursuant to CPLR 7804D, we request that these new arguments not be considered. Thank you for that. Moving on, with regard to the panel's decision, the panel had two holdings. We submit that
Are you there? I think we've lost you. Okay, I guess we will go on, and if she comes back, we'll give her 2 more minutes. But we'll go ahead and call the next case. Ms. Mitchell? Let's go on to the next case then, which is Prospect Capital versus Lathan. We'll hear from appellant. Mr. Gilbreth?
You're muted. You're muted, Mr. Gilbreth.
Sorry about that. Thank you, Judge Owen. Good afternoon, everybody, Your Honors, and may it please the court. This case clearly centers on the issue of an effort by an investor to enforce his rights under the offering documents drafted by the issuer of corporate bonds. The meaning of New York Banking Law 675 is, of course, front and center here. In addition to the important but relatively narrow
Counsel, this is Judge Owen. Counsel, this is Judge Owen. I don't think we have any, I think the issue here is whether or not the joint tenancy that was created by your clients is something that's actually a joint tenancy in its name, because of the way it's structured, that it may not be, quote unquote, a true joint tenancy. So how do you get around the court saying, you know, the agreements that your clients put out there, that all that combined collectively doesn't create a joint tenancy? What do you
think? Your Honor, you've hit at the central point here, and I thank you for your question. Under New York Banking Law Section 675, it is the intent of the parties that drives the outcome as to whether the joint tenancy is valid. Here we have certain record evidence. On the one hand, we have the writings of the parties. We have the account brokerage.
I'm going to interrupt for a second, because you're saying it's the intent of the parties, but if it's a legal impossibility in that the joint account does not meet the legal requirements of the joint account, it doesn't matter if the parties intended to create one. If they didn't create one, if it's not in reality a joint account, if they don't have joint control and joint ability to take assets in and out of the account, it doesn't matter what their intent was, because it doesn't meet the requirement.
Well, Your Honor, I would respectfully disagree with that. In fact, it is the intent of the parties, as stated in writing, multiple writings, that does drive the outcome as to validity. The intent, once the intent is manifested, Section 675 itself states that that is a high barrier or high hurdle to overcome, and it can only be done so in a number of very specific ways, none of which Prospect has demonstrated here. So here we have the written intent of the parties reflected in the account opening statements as well as in the participant agreements. Unusually here in these Section 675 cases, typically we have
Counsel, Justice Moulton, isn't it true that some of the account agreements provided that the non-party participants would not be entitled to take the entire estate in the event of the beneficial owner's death, the defendant's beneficial owner's death? Doesn't that defeat entirely your argument that these are joint tenants?
Respectfully, it does not, Your Honor. The contractual limitations on the economic interests as between the joint tenants do not, in fact, defeat the joint tenancy itself. I pointed the court to the most factually and legally on-point case called Grand Carrick, where both joint tenants had their rights to access the jointly held assets completely stripped away. And in fact, the assets that were put into that joint tenancy in the Grand Carrick case were provided by a third party. Here, the assets put into the joint tenancy were provided by either Mr. Lathan himself, or in some cases by investors in a fund whose assets were then put into the joint tenancy. So Grand Carrick, also the case of Smith versus Bank of America, where the parties have chosen to contractually modify the ultimate economic interests of the assets held in the joint tenancy.
Just going back to Grand Carrick, though, counsel, going back to Grand Carrick, that was involved the sisters, correct? Am I remembering correctly? And that sister, the one who didn't die, was entitled to the funds in a brokerage account. Isn't that correct?
No, in the Grand Carrick case, Your Honor, it was actually a third party who had funded the joint tenancy and was in fact entitled to the entirety of the contents of those jointly held assets. This is a highly unusual case, as I'm sure Your Honors have recognized. There really is no 100% on-point precedent, so we are left to argue the most analogous cases, and those two cases, in my view, are Grand Carrick and Smith versus Bank of America, both of which uphold the rights of joint tenants to contractually modify the economic arrangements as between them, as long as the written documents create that prima facie valid joint tenancy through the expression of their joint intent. We have that here.
Thank you, counsel, for your argument. We'll now hear from Mr. Burton.
Good afternoon, Your Honors. Of course, these were not valid joint tenancies.
But Mr. Burton, this is Judge Singh. Your adversary argues that really is besides the point. The point is whether Lathan intended to create a joint tenancy, and he did, and that essentially is the end of the inquiry.
Your Honor, that's only half the story. First, I will take this issue of intent, though, because it's obvious that there was no intent to create a valid joint tenancy. Mr. Lathan collected money from third-party investors for a hedge fund. He purported to establish joint tenancies with perfect strangers. These were people who were living in hospices that Mr. Lathan had no prior relationship with.
Well, but he said he was providing a service. People were getting money at the ends of their lives, so there was a service provided.
Yes, Your Honor, that's correct. But the issue is whether Mr. Lathan intended to give a gift of one half of the funds that provided by his investors to each of these perfect strangers. The answer to that question is, of course he didn't, and nor did he. In fact, Mr. Lathan retained the right through all these side agreements to take money in and out of each account. This was never the property.
Well, counsel, this is Judge Owen. Not only did he do that, he also said that if he predeceased the investors, that money that would be generated would not go to the investors. It would just get back whatever they put in, and that's the end of it.
That's exactly correct,
Right.
Your Honor. That's exactly correct. That's exactly correct. And that's why
I get to keep everything and they get nothing.
Sounds like a great plan, but it's just not a joint tenancy. And I'll give you an example that the court below pointed to that shows you just exactly how frivolous the argument is, that there was an intention to create a joint tenancy and that one was actually created. There was one particular participant Davis, who in 2011 was diagnosed with terminal cancer. Mr. Lathan signed her up as a participant, put millions of dollars into the account, and miraculously she recovered. So what did he do? He took all the money out of the account and gave it back to his investors and closed her account. So that was never her money. Half of the funds were never her. It was never her property. The property was always owned by the hedge fund because that's who provided the money to open up these investments. And that's an independent reason why these joint tenancies fail, because a hedge fund or any corporation cannot own property in joint tenancy. And I understand why Mr. Lathan entered into all these side agreements that he never disclosed to Prospect at the time he was trying to redeem these funds. He entered into them to convince his investors to give him the money in the first place. If he had told them, look, I'm giving your money, half of it, you give me $1 million, 500,000 of that goes to somebody you don't know, I bet you he wouldn't have raised a penny. And I'll rest on my papers unless the court has any additional questions for me.
Well, counsel, he needed the investors to actually buy the bonds, right? I mean, that's the bottom line. And then he took the investment, and as my colleague Justice Singh said, he offered $15,000 for funeral expenses to these participants.
That's correct. So what he did was he that's right. He sought the money from other investors for his hedge fund, took that money from the hedge fund, bought bonds with it, and gave the participants $10,000 or $15,000. That's it. That's all you get. The rest goes to the hedge fund. If there's any profit made, it goes to the hedge fund. So none of that goes to the participants.
Thank you very much, counsel.
Thank you.
The next case is Gorlick versus Cushman Wakefield. We'll hear from Mr. Tucker.
Good afternoon, and may it please the court. When distilled to their essence, these appeals are quite simply about the meaning of the phrase, if your role is eliminated, which is contained in the offer letter and the provision for severance in Mr. Gorlick's agreement. The operative phrase of the severance provision is only susceptible to one reasonable meaning, and that meaning is if the function Mr. Gorlick performs at Cushman and Wakefield is eliminated. It is undisputed that the function Mr. Gorlick performed at Cushman and Wakefield was leadership of the America's retail services business, and that this function was not eliminated. Based on these facts, Mr. Gorlick is not entitled to a severance payment
So
under
why
the terms.
is the agreement ambiguous as to what your role means or does not mean? Well, couldn't it be interpreted in two different ways?
Well, Your Honor.
What you do versus the role generally?
Well, Your Honor, I think it's not susceptible to multiple interpretations because of the application of the Platek decision that was cited and relied on in the briefing. And this is the Court of Appeals case involving an insurance coverage issue as to whether something, what resulting means, whether it means follows or is caused by. And in that case, I think it's reasonable to conclude that generally speaking, resulting from could mean caused by, it could mean follows. But the court relied on the fact that caused by was used elsewhere in that particular agreement to conclude that it could not mean resulting from in that context. And I think that's exactly what is the case here. The two other interpretations that have been put forth, both position and employment, are used extensively in the agreement. I believe 5 and 4 times each, whereas function is not used, right? So had the parties intended for the severance provision to trigger upon the termination of employment or elimination of position, the fact that they use those phrases elsewhere in the agreement suggests that if that's what they wanted, they would have said that, but they didn't say that. They said role. And so there has to be a different meaning. And the only plausible meaning and reasonable meaning that comports with that Platek decision is function. And so, and in the employment context, position and role are sometimes used colloquially or interchangeably, but they are distinct, right? It's a difference, and it's a subtle one, but it's a significant one. And here, the position is the job. the role or the function are the duties that are performed by the person in that job. So whereas when a position is eliminated, it's often a cost saving measure to reduce headcount, to eliminate a job. That doesn't follow that the role is eliminated, and in fact, often the role.
Though, just from looking at the agreement, I understand you're saying that's the custom in the industry, but just looking at the language in the agreement, how would a reasonable person know as a matter of law that one interpretation versus the other is correct? I guess you know, last question, but I don't know that you've answered it to my satisfaction.
Well, I think it's a matter of elimination, right? My argument is that the Platek decision eliminates the possibility of position or employment, and so as possible meanings for that word. So all that's left is function. There isn't another possibility.
Counsel, I would note, and this is what's sort of giving me pause, is what the provision says: if your role is eliminated during the first 18 months of your employment, doesn't that sort of make it ambiguous as to precisely what you're meaning in that phrase?
Well, Your Honor,
you didn't say if your employment, you could have said your employment is eliminated during the first 18 months. You have a stronger argument, no?
Well, no, I mean, I would argue that, again, going back to that Platek decision, we're using the term employment in the same sentence as the word role, right? So
I'm sorry, but to my colleague's point, how is a person who leaves a job to take another job is to understand that from that language?
I think it's, again, going back to the custom and usage of the term. Role it's an industrial term concept in employment, that I have a role, what I'm doing, right? That's really what it's about.
Sounds like what you're saying is that parole evidence is necessary to determine what is the custom and practice in industry with respect to usage of these terms?
Well, no, I mean, I would argue that this is a plain meaning. Again, role means function. Whereas, again, with Mr. Gorelick's argument that employment or termination of employment is role elimination, it just doesn't comport with the plain meaning or regular usage.
Do the justices have any other arguments? Okay, we'll hear then from opposing counsel, Mr. Fertel. Mr. Fertel? Are you there? I see his initials.
I see his video. He's not talking.
No, maybe there's some problem. Mr. Fertel, are you present?
Mr. Fertel.
Judges, can you hear me?
Oh, there you go.
Yes.
I'm lost. You can't hear me?
Yes.
Yes.
All right, I'm gonna have to. I can't hear you. I'm sorry. Can I be called again? Let me try again, Judge. I'm trying to get to my settings. I lost my. Hold on a second. Can I can't hear anyone. Can you hear me?
Yeah,
we can hear you.
We can hear you.
Yeah, we'll come back.
Sorry, my AirPods died in the middle of that argument.
We'll come back to you after the next case, and if
me
you
try again.
can't hear us, you can't hear what I'm saying now. If you can't hear us.
I'm sorry, Your Honor. Can I get called at the end for my argument, please? So I can get it set up? Oh, wait, can you hear me now?
Yeah, yes. Can you hear us?
My apologies.
We'll call you at the end. Counsel, Mr. Tucker, if you could remind me just in case I forget that we have to call it again. Okay.
Can I get called at the end, please?
Yes, more
Thank you, Your Honor.
Spaces.
Yes.
Good afternoon, Your Honors. May it please the court, Scott Horn, counsel representing the appellants who are the tenants in this controversy. It's our contention, Your Honors, that the judgment awarding some $175,000 for alleged property damage should be reversed on several grounds. First, the landlord's proof of damages in the form of past and future repairs is legally insufficient as a matter of law. The legal standard is clear on this point, and it required the landlord to prove that any alleged repairs undertaken are both necessary and reasonable in value. Respectfully, Your Honors, the landlord proved neither. And in support of their claim for alleged past repairs.
Counselor, this is Judge Singh.
Yes,
Doesn't
Judge.
this case turn a lot on credibility? There were photographs were put into evidence which purportedly show damage done by dogs, for example. The judge made certain findings with respect to that. How do we reach those credibility determinations?
Sure, Your Honor. So yes, of course, in a situation like this, where you have a landlord and you have a tenant, and you have competing claims as to what the condition of the apartment was and who was at fault for that, credibility certainly comes into play. Our primary arguments with regard to proof are judgment as a matter of law situations, legally insufficient proof of damages.
So address the photographs. Address the photographs. There were photographs in the evidence, and the court viewed the photographs and made findings with respect to what the court believed was shown based on the evidence.
Yes, I understand, Your Honor.
And counsel, this is Judge Owen, and to just Judge Singh's point, your client, one of your clients was actually there on March 1st to do the walkthrough, right? Correct?
That is correct, okay. Your Honor. Mr. Moore was present that day. In fact, that actually speaks to the adverse inference charge that wasn't given, because the court gave an adverse inference charge for Mr. Moore's not testifying at trial, and denied our application for an adverse inference charge for the videotape that was taken by the landlord.
So
but if you speak,
the photographs though have the same exact thing as the videotape? Didn't they show the same exact things that the video would have shown?
No, Your Honor. In fact, the date that the photographs were taken have never been established in this record. That's A. B, the videotape, there were many aspects of the damage claim that were not reflected in the photographs. Presumably the videotape would have shown those areas during the walkthrough. But moving beyond the videotape, Your Honor, if we're going to look at items such as credibility and judicial rulings, the court's determination to preclude the tenant from offering a defense to the property damage counterclaim was erroneous. We respectfully submit that the trial court's ruling deprived the tenant of a full and fair opportunity to defend against what was essentially the heart of the case.
Couldn't one argue that essentially it would be cumulative of Ms. Moore's testimony?
Absolutely.
And isn't that, again, a discretionary decision of the judge under those circumstances?
Absolutely not, Your Honor, and here's why. The individual who is going to come in to testify was a disinterested, objective witness. He was a contractor who had been hired by the landlord. He would have been. Yes, Your Honor.
When did Mr. Sappho's name, the person you're talking about, when was it first raised with the court? Like
this
before
had
the
been.
Hearing began, did the plaintiff say, or excuse me, did your client say we're calling Mr. Sappho?
Absolutely, his name was on the witness list, Your Honor. That's as straightforward as I can answer that question. And what happened was the court apparently misunderstood what the nature of the competing claims were here. Because on the one hand, you have the plaintiff who's seeking a return of a down payment, a security deposit rather, who puts in a very perfunctory prima facie case with the understanding that she would have the opportunity, the tenant, to defend against the property damage claim. The plaintiff could not have foreseen how the landlord was going to testify in such a hyperbolic manner. The plaintiff could not have foreseen the dubious nature of the documentary evidence that was submitted, unitemized invoices, unitemized proposals, checks made out to different entities, bank statements. All of these things would have been attacked in defending against the counterclaim. Mr. Sappho was literally the only objective person, contractor, that was present at the time after the tenants had moved out. He would have been a critical witness. He was disinterested.
And here now from opposing counsel.
Thank you, Your Honor.
Are you there?
I am, yes. Can you hear me?
Yes.
Thank you. Yeah, we certainly contend that the court got it almost all right, that this was a credibility determination and the judge got it right with the one major error we believe of he should have awarded us the legal fees because we were the prevailing party.
Counsel, can you speak to the exclusion of Mr. Sappho and his testimony?
Sure. I believe it was the judge rejected him because the judge had indicated at the outset he saw a very limited role, practically no role for rebuttal, and counsel kept insisting he was going to call a rebuttal witness. So he was talking right past the judge. He didn't come out to the judge and say, I want to put this on the counterclaim. Miss Moore, contrary to what counsel just said, that she was going to hold all her testimony till after Miss White testified. That's not true. As he said in his opening statement, we're going to prove in our prima facie case, we're going to prove we left the place beautiful, nothing but ordinary wear and tear. And then at the end, he said she testified for hours about what great condition she left the apartment in. So the parties treated the claim for security deposit and the claim for the property damage as just two sides of the same coin. What was the condition of the apartment on the day that the day after they left and they did the walkthrough? And Mr. Sappho, who, by the way,
Counsel, this is Judge Cohen. I just want to have you address the issue of attorney's fees. Why did you not bring a counterclaim for breach of the lease? Instead, you phrased it as a damage claim. And how would that impact your request for attorney's fees?
It's actually, no, it's phrased as a counterclaim for breach of the lease. It cites the provisions of the lease that were breached.
Do you have it in front of you?
I'm just turning to it right now. Yeah. Page 30. Right. The first counterclaim, it's on page 32 of the record, states that the parties have a lease. The lease requires that the apartment be taken good care of, the apartment, the equipment and fixtures, that the areas be kept clean, that the apartment be restored and returned at the end of the term in clean and good condition. At paragraphs 9, at paragraphs 19, paragraphs 30 of the lease. Plaintiff breached the lease in that during their occupancy, they severely damaged the apartment. For reason of the foregoing, defendant has suffered damages.
So your claim for attorney's fees is based on the breach of the lease for failure to keep it in the condition that was required under the lease.
Exactly.
Ms. Hurley, did the judge make any findings with whether or not there was a breach of the lease, or was it just limited to the damages?
The judge's order simply said it's more in the nature of a tort.
Of a tort, I understand that.
Right.
Nothing.
I believe I'm just looking at his decision. I believe that's all he said was he considered it to be more of a tort. But the cases I've cited in my my reply on the cross appeal point out that this court has found relatively recently that when it arises under the lease, it really is the relationship, the duty of the Moores to maintain the property arose from the lease. That's the basis that's where their obligation comes from.
You were not given an opportunity to show the amount of attorney's fees below, correct?
That's right.
Okay, are there any other questions from the justices? Okay, thank you very much for your argument.
Thank you.
This is Barry. Thank you, Your Honor. This is Barry Fertil. I got my sound back. If you want me to go now or wait till the end, I'm defer to you.
No, you go ahead. Is your opposing counsel still here, right?
Yes, I believe so.
Yes.
Yes, Your Honor.
Yeah, I apologize. My AirPods died right in the middle of the argument. Your Honor, thank you very much. This is not a complicated case. It involves around interpretation of a single provision regarding a severance payment to the plaintiff. If you were shown this provision without any lawyers showing it to you, you would not have said to yourselves, oh, this word, your role must mean the function or the duties. That's only because after when the summary judgment motion was made, after they never replaced Mr. Gorelick, that Ms. Hay decided to come up with this definition based upon a dictionary as to what the role meant. It refers to your role. And
Mr. Fertel,
yes.
Isn't there support for your adversary's argument when you look at the final sentence of the agreement where it discusses your role, and we're excited at the prospect of you joining us, and you will be challenged and fulfilled in your role with.
You could substitute the word for your role, your involvement in the company, your being at the company. You know, to that extent, it's not as clear. They could have said it much more specifically and expressly. They refer to the position in the beginning of the agreement, and as your honors know, they didn't assert the issue, this particular definition or this particular interpretation, which I believe they should have in their answer, until after the time to make a motion for summary judgment was made, and because they had not replaced. By the way, the original interpretation that was in their letter from their attorney saying the role is open. Until we find someone to fill it, it will be open. Well, that contradicts their argument before you that the role is not open. It's not open if the duties and responsibilities are shifted to someone else. But their attorney, immediately when they terminated my client, decided to say, well, the role is open. I should also note the very purpose of this provision, the very purpose was to address the concerns of my client that he be terminated without cause, and it was inserted at his request for his benefit. So to construe it in a way that basically takes away every right he may have, because, by the way, the provision is meaningless if you take their definition, because all they have to do is say, well, we shifted the functions and duties to someone else. You'll never get any severance. We don't care if you're fired. That's unfair and not the purpose of the provision and the intent. The intent was to protect him if he was terminated without cause. That was the purpose, and then they reneged on it. Now, it's clear the case they cite, Platek, deals with a totally different situation involving an interpretation of a complicated insurance agreement. This is a fairly simple agreement involving employment of someone who was attracted after 45 people were interviewed, and they really wanted him to work for them. And then they decided to terminate him 6 months after he was hired without cause, and he should be compensated by severance. That's what the severance provision is for. The provision says then the regular severance procedure would kick in, which would imply that the regular severance provision, where you would simply get based upon your time being there, would apply. So I think, Your Honor, I would disagree with you. The fact that your role is used there refers to his involvement in the company, his being there, his actually being in the company. They could have used other language if they wanted to make it clear. The only testimony is the testimony of my client and the testimony of the person who hired him, that this proposed interpretation they've offered was never discussed by anybody. Now, if they really wanted to limit it to those very narrow circumstances, somebody would have said, this is what we meant and this is what we decided. Instead, they submit a self-serving affidavit only when the summary judgment motion is made, saying this is what it meant, because they looked it up in a dictionary and they found this interpretation. And as far as custom and usage, which Mr. Tucker raised, there was never anything written about custom and usage being applicable here. It was your role, meaning him, meaning Mr. Gorelick. He was terminated. He's entitled to severance.
So custom and usage, counsel, would suggest an implicit concession that there's an ambiguity, right? Because presumably that custom usage would come in at a trial.
Well, I disagree in the sense I don't think custom usage would be involved, because that deals with two parties who are involved in an industry that they're both involved in, and this is really an employment agreement that's specific.
But wait a minute, this is a very specific kind of industry, so it's not your regular employment agreement, right?
Well, of course not. You rarely have an employment agreement with a severance provision such as this. I agree with that. I'm not so sure custom usage will come in, but we've also moved for summary judgment, as you know, and we've cross-appealed and we've sought summary judgment. Justice Scarpullo said there were differing interpretations. The defendant had differing interpretations. Their first interpretation was the role is open if he's terminated. Then they come up with another one because he was never replaced, that, well, it's not whether he's replaced or comes back. It's simply whether or not the duties and functions are shifted to someone else, which, by the way, can be an issue of fact, because who knows whether all these duties and responsibilities were actually shifted and taken over by somebody else.
Thank you.
I'm sorry.
Do justices have any more questions? Okay, we're going to go back on to the regular.
My apologies, by the way.
Glad you got back on.
Thank you, Your Honor.
The next case is going to be Tracy versus Inspired Events. We'll hear from Mr. Generelli.
Good afternoon. Can you hear me?
Yes.
Okay, great. Gregory Generelli for Plaintiff Appellant. This case arose out of a workplace accident in a loading dock at the Marriott Marquis back in 2011. The plaintiff was working for a trucking company at the time, making a delivery, unloading, and transporting construction materials when he was injured when a one-ton
Mr. Generelli,
crates.
this is there are a lot of defendants and moving parts in this case. Can we just eliminate one thing, which is you're not appealing the dismissal of the labor law 200 or straight negligence, right? I mean, there's no argument in your brief.
Correct. That's correct.
Thank you. Please continue.
So when several crates weighing about 1,000 pounds fell onto them while they were in the process of being hoisted, lifted, pulled to the back of the truck, removed, and transported to a loading dock so that other pushers could take them up.
Current. Why would your client be covered under the labor law when not only was your client not at the construction site, there was no possibility under the circumstances of this case that your client would ever be at the construction site, since the union rules required that he drop it off at the dock, which was a permanent structure at the hotel, and he had no ability or right or obligation to actually go anywhere near where the potential construction site was going to be.
Well, Judge Kurt, I think that has to deal with whether or not the area where this happened is considered part of the construction site. Now, this court held construction site. Sure, this court held several years ago. I believe the case was Hoyos versus New York, 1095 Avenue of the Americas, that a loading dock, which is where this incident took place, is part of the construction site in a situation such as this in Manhattan, where it's a high-rise building, and that's the means of access to the construction site. So whether or not it happened on the loading dock or right inside the loading dock, I think that case indicates that the plaintiff would be protected. In Hoyos, it was a painter who was going to go inside to perform work on construction.
I'm sorry, counsel. Counsel, this is Judge Singh. Yes. What you just said, doesn't that distinguish it from what happened in this case, based on what his duties were here, that the crates were to be dropped off at the loading dock, and then others would come to take the crates inside and erect the booths?
Well, he's inside. The truck is inside in the loading dock. If you look at the video that's attached as part of the record, and also
my point being, the painter in the case you cited was going inside to do painting. In this case, the plaintiff was not. He couldn't under union rules.
Well, does that change the nature of whether or not the area is a protected area? I don't believe that it does. The worker, while he may have been going in, had not yet made it in.
Counsel, doesn't it change whether or not he was ever going to be part of the construction site or part of the construction? If his role could never be part of actually being involved in the construction, doesn't that distinguish it from the other cases?
I don't think that it does, for the simple reason that there are numerous cases, many out of the second department, with respect to the loading and unloading of trucks. So there are many instances of workers, whether it's construction supplies, steel, rebar, that simply drive to a site or to a loading dock.
Aren't they actually going aren't they actually going to the construction site in those cases? The cases you're talking about, the delivery was actually occurring at the construction site. Here, the delivery was not occurring at the construction site. It was occurring at the loading dock, which was in no way part of the construction site. Doesn't that make this case different?
I don't think that it does. And I think what you're getting at is you want to draw lines as to where the construction site starts and where it stops. And in a situation like this in Manhattan, in a high-rise building, you can't really do that, because the only area where he can make this delivery is in the loading dock. If this was a construction out in the middle of Brooklyn, he could drive up to it. He would perform the same task.
Counsel, isn't the real issue, though, that in this case, there were union rules that prevented him? The only thing that prevented this driver from actually bringing the stuff inside was not the nature of being in New York City. It was because the union rules prevented him from ever being able to be take the next step of bringing the materials to the construction site.
But he's already within the premise of the construction site when he pulls into the loading dock. They're on Marriott property there. That is the construction site. So once he arrives at the Marriott, he's entitled to those protections under the labor law.
Council, was the hotel under construction?
The hotel was not. The portion of it was for the purpose of this Imagine Cup that was being put on by Microsoft. There were numerous structures being built for this, and it was part of the process.
Do the justices have any other questions? Okay, let's hear from Inspired Events then.
Good afternoon. This is definitely a strange way to do this. My name's David Schultz. I'm with Barry McTiernan and Moore. We represent Inspired Event Productions in this case. As for Inspired, there were many reasons for the complaint to be dismissed against it, and the lower court started with the broadest one, that plaintiff's work does not fall within the labor law. In his decision, he went through the standards for what constitutes work under Labor Law 240, what constitutes work under Labor Law 241-6, what constitutes work under Labor Law 200, and concluded that Mr. Treacy's work fell within none of them. In essence, they followed the Court of Appeals decision in Pratt's, which sets out the 4 factors in which trying to figure out if certain work is incidental or related to an ongoing construction. And in this, considered, did Mr. Treacy, was he employed to do construction? No, he wasn't. He was a teamster who was at the hotel to unload a truck. Was his work ongoing and contemporaneous with any construction or alteration or anything covered by the labor law? Answer to that is no. What he was doing was unloading a truck, and as the justices had pointed out, he was not planning on going onto the site. There were strict union rules that for.
So counsel, this is Judge Singh. Your adversary argues that the fact that he is at the loading dock is sufficient for protection under the labor law.
No, because as Pratt at the last section of Pratt's is, if somebody is on the job site but doing a job that is a separate phase, easily distinguishable from the other work on the project, that it is not incidental and related. And in this case, because of the union rules that severely limited what Mr. Treacy could do on this job site, that context is important. So even though the loading dock is in the building, it has no connection to any of the work going inside. And that also incorporates the assumption that what was going on inside the hotel would even qualify as covered by the labor law in and of itself. The lower court never got to that fact, as it just found Mr. Treacy's work was not covered by the labor law at all, but the work going on inside was also not work covered by the labor law. But
It also hadn't even begun, isn't that correct? The work hadn't even started yet.
The record was a bit unclear as to what work was ongoing inside the building at the time, but they were setting up for a Microsoft's Imagine Cup 2011. They were going to bring a bunch of people from all over the world to share ideas and what was going to go on inside. And here, Microsoft was a guest at the hotel. It was not Microsoft's within their ability to start changing, modifying, altering the structure.
On that note, let me hear from Microsoft.
Okay.
Okay.
All right, but in that regard, so as far as that,
hear from Microsoft now.
Oh, okay. Oh, sorry.
I'm done.
I thought you meant leave that topic to Microsoft. I'll stop talking now.
Okay.
Thank you, Your Honor. This is Allison Sherry of Davis Wright Tremaine on behalf of Microsoft and Marriott. I thank my colleague for starting my argument for me here. I just wanted to address one point that the plaintiff had made in focusing on the loading dock as a specific kind of locus of the legal issue here. I think the case law here is clear that it's not about where, it's about what the plaintiff was hired to do broadly at that construction site. So the courts have certainly cautioned against looking too narrowly at, was he at that specific moment engaged in something that could be considered construction, but what was he there to do that day as part of the job? What was his employer Why was he brought there by his employer? And here, as Your Honors noted, Mr. Tracy was brought to the site. His only sole job was to unload the crates. His job stopped at the loading dock. He was not permitted to move the crates inside. He was not permitted to open the crates. He was not permitted to set them up. So, you know, the plaintiff's focus on what was in the crates, what was going to happen with the crates is really beside the point. And whether they were unloaded at a loading dock, on a curb, in the middle of a field, it just doesn't really matter here, because the point is that the plaintiff's job was very limited in scope and had an endpoint. And when he had unloaded those crates, his job was over, his employer's job was over, and he was never entering the site where any assembly of structures or any construction was going to occur. And I can also address, I think, you know, in addition to, I think the case can obviously be dismissed, you know, for that reason alone. If the justices would like me to address kind of the other reasons that there exists to.
Have any other questions? Okay, thank you very much.
Thank you, Your Honor.
We'll now hear from Work in Progress.
Yes, Your Honors, may it please the court. This is Mark Aladort representing Works in Progress. My co-counsel have already gone over the issues generally why the labor law would not apply, but my main arguments, both in my motion and my brief, are that even if Your Honors disagree and believe the labor law in general may apply to this case, it certainly does not apply to Works in Progress. And plaintiffs' brief and arguments and motions before this court all argue as against Microsoft, Marriott, and Inspired Events. I could find no real arguments against my client Works in Progress other than he refers to them as an agent. There's no factual basis cited, there's no case law cited, but he refers to my client as an agent. But under Russin, which is a Court of Appeals case, to be found to be an agent for the purposes of the labor law, you must obtain the authority to supervise and control the work that was ongoing at the time. Here, it's uncontroverted. Works in Progress was orally retained by Inspired just to handle logistics. The testimony was that they did the scheduling and coordinating, so they didn't have 10 trucks show up at the same time to be unloaded. She had Works in Progress had absolutely no role with regard to the loading of the crates in the Netherlands and then the unloading of the crates, which they were doing at the time of the accident. Also, the First Department in Serpe determined that you must have control over the work being done and the authority to insist that proper safety practices be followed. Here, not only is the testimony that Works in Progress had nothing to do with safety or was not retained to that, this work was being done by the Teamsters Union. She had no authority whatsoever to tell the Teamsters Union how to do their work. That's what these unions do for a living. And plaintiff admits at his deposition that all of his instructions and control that day were by Bud. So we believe it's clear, uncontroverted, and technically unopposed, because I really could not find any arguments by plaintiff. The only mention of Works in Progress in the reply brief is that plaintiff, and I quote, "With respect to Works in Progress, while we believe that the responsibilities designated to it overseeing certain aspects of trucking and delivery of materials make it a statutory agent, we concede its status is not as clear as that of Inspired Events." That's their only argument, which clearly does not apply. There's no factual or legal basis that Works in Progress was an agent.
Thank you. I don't know if Mr. Suarez has ever come on board or not. Are you there, Mr. Suarez?
Yes, Your Honor.
Okay, why don't you go ahead then?
Thank you, Robert Suarez, for the respondent, Ports America and Port Newark Container Terminal. Unless the court has any questions from me, Ports America and PNCT rest on the papers submitted on the appeal.
Are there any questions? Okay, thank you very much.
Thank you.
Okay, the next case is Russell versus New York City Fire Protection. Mr. Seelig.
You're muted, Mr. Seelig.
Are you there, Mr. Seelig?
Yeah, he's muted. He's muted. Uh-oh. Can't hear him. Oh, no.
Okay, why don't we go on to the next case? We'll come back to that. Why don't we do 186 Norfolk?
Can you hear me now?
Oh,
Your
yeah.
Honor?
Are you there?
Yes, can you hear me?
Yes.
Okay, I had to go off my computer and onto my laptop because computer, for some reason, the sound wasn't working. So I apologize for that, but may I proceed then, Your Honors?
You may proceed.
Thank you. So my name is Phil Seelig. I'm representing Lieutenant Russell. Lieutenant Russell hurt himself when he slipped at the bottom of a staircase, and the medical board of the pension system determined that his arthritic condition was the cause of his disability. There are three issues that I'd like to focus the court on, which I think are the salient issues in this case. The first has to do with the Supreme Court erroneously transferring this matter to the Appellate Division. It was punted by the Supreme Court Justice, but in cases like this, it was an error because the Justice believed that the Board of Trustees and Medical Board determination constituted a hearing or a trial, and therefore it would be.
So what's the remedy you're seeking, counsel? Do you want to see the case?
I didn't hear you, Your Honor.
What is the remedy you're seeking with respect to that issue?
Well, I think it's appropriate for the appellate court to hear this case and other cases like this in the interest of judicial economy. The appellate court should make the decision here, but it should be under the credible evidence standard rather than substantial evidence. And that is not opposed by the opposing counsel.
So is there, counsel, is there credible evidence that supports the finding of the medical board?
No, I don't believe so. And I want to point to the other 2 points that bear that out. So the first has to do with the determination by the medical board and their own statement, which occurred on page 97 of the record. And I want to quote the one sentence that I think is relevant. It says, when we thoroughly reviewed his operative note and found that there was a bony spur, which was arthritic in nature, which was most likely the cause of the tear in the labrum following the incident. And as you know, this case, like many other cases where there is an arthritic component, it falls under the Court of Appeals case Tobin v. Steisel. And there, if there's an aggravation of a pre-existing condition or the precipitation and development of a latent condition that would cause this person to become disabled, and it occurred as a result of an accident at work, they're entitled to accidental disability. So here, the member did have a arthritic condition, which was latent, and the medical board found that the tear that occurred followed the incident. So their arguments that they conclude that it's based on an arthritic condition is undermined by their own statement.
Now, Counselor, in this case, there was an MRI taken a few days after the incident, correct?
There was an MRI, correct.
It didn't, or according to the medical board said that there were cysts in the area, which, according to the medical board, is indication of chronic degeneration disease, and it's not an acute injury. How do you respond to that?
Well, two things. One, there's never been a court determination that I'm aware of that requires an acute injury. And acute is used in two different forums. Acute, as we understand it as laypersons, while attorneys or judges, means a very severe condition. But acute in the medical terminology means rapid onset. And since he was asymptomatic before, was working full duty before, a sprain, a strain is a rapid onset and is an acute injury. So despite their proclamation, which is not credible evidence in and of itself, merely their own proclamation doesn't constitute credible evidence.
Mr. Seelig, I'm sorry. What supports your client's position, other than his statements, that in fact that there was no prior hip injury?
It's the third point that I wanted to raise, Your Honors, and that has to do with their statement in their last medical board report, which was on page 101 of the record. And here they said, due to the fact that there is no evidence that there was a previous significant injury, and this is a re-exacerbation of that injury, Tobin versus Steisel is not of issue. And that was their final medical board report upon which the Board of Trustees voted. This shows a profound misunderstanding and misapplication of Tobin v. Steisel. It was the medical board's belief that there was a requirement for a previous significant injury prior to his line of duty injury causing him to stop returning to full duty.
Do the justices have any more questions? Okay, we'll hear from your opposing counsel.
Thank you, Your Honor.
May it please the court, Claiborne Henry on behalf of the Fire Pension Fund. It is plaintiff's burden to establish as a matter of law that this purported accident on the job caused his disability, but he simply hasn't done that.
Well, but what about his statement, counsel? You know, prior to the incident, there was no hip injury, no hip pain, and he only sustained it. It exacerbated maybe a degenerative condition after the incident.
A petitioner's subjective reports, while relevant, are certainly not dispositive on the issue of causation, and the Court of Appeals has said that's so. I mean, in Tobin, which he relies heavily on, the Court of Appeals sustained a denial of ADR benefits despite the petitioner reporting being asymptomatic before his accident. It simply doesn't constitute the type of objective medical evidence that is needed to earn ADR benefits. If all a firefighter had to do was to report an accident and then claim that they had developed symptoms after the accident that were unresolvable, really anyone could get ADR benefits and be entitled to the substantially higher payout that it provides. And so again, while it's relevant, it's not the type of evidence that he needed to present. And that's really what this case boils down to, is his subjective report about the timing of the onset of his symptoms, and then his doctors essentially parroting that assertion. But it's just not sufficient as a matter of law. Aside from that, the only other evidence that anything happened to him at work is this labral tear in his hip, but it is undisputed that labral tears are just as commonly found, if not more commonly found, in people with chronic conditions like he indisputably had. Then they are found as a result of acute injuries. And so what we're left here is no real objective evidence to establish his claim as a matter of law. And, you know, I am not arguing that the Fire Pension Fund has established as a matter of law that his accident is unrelated to his injury. He simply hasn't established as a matter of law that it is related, that it has caused his injury. And it was his burden. And as long as there's a question of fact on this issue, this court must confirm the Board of Trustees' denial of ADR benefits predicated on a tie vote.
Thank you, counsel. We'll now hear 186 Norfolk, appellant.
Yes, Jonathan Wallace for the appellant. Good evening, Your Honors. This case at the very highest level is about what the word rights means in the term of art, succession rights. The plain English definition of a right is that it's a claim recognized and delimited by law. That's Merriam-Webster. So if a succession right...
Counsel, we have a split in the departments here, right? I mean, that's just
Yes.
what it comes down to in terms of on this fact pattern.
That's correct, Your Honor.
So essentially, I think what you're asking us is to overrule Third Lennox, correct?
I have an argument in the alternative that you can distinguish it. But yes, Your Honor, I'm going straight forward.
Well, how would you? Well, why don't
ask
you
you to overrule it.
distinguish it before you tell us why we should overturn it?
Well, you can distinguish it because most of the cases have to do with sisters, children, and parents. And so relationships where the succession rights are created exclusively by the rent stabilization law. and the rent control laws. In this case, because we had a marital relationship, I would argue that those cases need to be treated differently anyway, that there was an interest in the apartment that was created by the domestic relations law, as the case of Kudar versus Kudar indicates, that's quite separate from any succession rights that were created by the rent stabilization or rent control laws, Your Honor. But coming back to Jourdain and the conflict, the very first paragraph of Jourdain, Your Honors, actually disposes of this issue correctly. It says that can the rights that are created by the succession laws be lost? Can you lose that right by virtue of the fact that the tenant continued to pay the rent? And it holds, no, you can't. So it's an analysis in terms of the actual meaning of the right. Third Lennox is actually, Your Honors, kind of a very strange case philosophically, because the appellate term in deciding that case never dealt with this issue, never asked itself the question.
Third Lennox again, though, counsel, after Third Lennox was decided, don't we have a more recent case where we again followed precedent? So
Well done.
Well done. Those
Yes,
cases.
you followed it several times, Your Honor.
So what would have to overruling a even more recent decision where we once again affirmed that we were going to be following it?
Well, I suppose that's true, Your Honor, but in the interest of fundamental justice, the question really arises. If I were asserting a First Amendment right, okay, in any context, either as a plaintiff or as a criminal defendant, I assert a First Amendment right, and you tell me that I've lost that right through the failure to file a piece of paper, which I had no reason to know I needed to do, that would be a very unusual rule. If the legislature passed that as a law, I would be here arguing that it denied due process, because the law outside of the realm of Third Lennox is just universally
But
that
Mr.
you cannot
Wallace,
accidentally lose a right.
Mr. Wallace,
Yes, Your Honor.
you know, I assure you, at least speaking for myself, I'm not unsympathetic to your arguments, but isn't the proper remedy here is, if we were to not support your position, is to take it up to the Court of Appeals based on a split in the department?
Absolutely, Your Honor. I'm obviously here have to argue something to you, so I am arguing to you, but I absolutely would try to take it up to I would move for leave, Your Honor, because I think it's that important in issue. I just, if this had to do with a liquor store, then you could say to me that as the owner of a liquor store, I inserted myself into an area of commerce where I had the duty to know the rules, Your Honor. But this is a mere homeowner with minimal education. This court and the appellate term itself have in other contexts talk about the thicket, the morass of regulations that exist in housing.
Your client and his ex-wife both represented in 2013, many years after their marriage had ended, that they were spouses and husbands. That's not correct. So making that kind of representation is a lie. So that's, you know, anybody knows that. And
yes,
also, you know, pretending that you're signing checks on behalf of your ex-spouse, or that is what you're doing, you're signing your name. And, you know, why would one have to do that? Because your own checks were rejected. Why were your own checks rejected? These are all basic questions that anybody can ask of themselves.
Well, that's correct, Your Honor. But the fact is that words get thrown around in Third Lennox cases that are used colloquially when they have legal meanings to them. So the consequence of the very rigid Third Lennox rule is that we use words like fraud, waiver, and laches that simply lack the definitions that would be applied in any other kind of case.
This is Judge Owen. This is Judge Owen. I want to put aside for the moment all the, you know, in terms of what your client did, in terms of the alleged dishonesty and all. I'm going to put that all aside. I'm going to look at the timeline here. And Third Lennox talks about timeline. And in this case here, if you just look at straight timeline, and I'm not, as Justice Singh says, I'm not unsympathetic to what you're arguing. But if you look at the straight timeline, according to the record here, the ex-wife or the tenant left sometime in the 1990s. So there was no co-occupancy between 1990 and the time the tenant actually gave notice to the landlord in 2013 that I'm vacating the premises. So that if you do a 2-year look back, you need to still have co-occupancy. It's not there. So if you do the straight timeline, the client is not going to prevail. It's kind of difficult to prevail. I mean, you're putting aside, I understand, because this is a very big case in the sense that it's going to capture a lot of other people. But in terms of just, if you look at the straight timeline, I mean, you always can make the argument, look, you know, it's not fair. It's not fair. I mean, you have all these, I hear what you're saying, but at some point we got to have some sort of rule.
Yes, Your Honor, but
Lennox says that rule. It has that timeline.
But it's judge-made law. It's not the legislature. If you go back to the rule itself, as it's expressed, it was interpreted in Jourdain by the Second Department.
Wait a minute. You mean the 2-year look-back period for co-optancy is not judge-made law? That's in the statute.
No, the statute says they have to have lived together for 2 years. What the Third Lennox added was that it had to be 2 years immediately before the last renewal. That's judge-made law.
I give you that. I give you that. But between 1990 and 2013, there was no co-occupancy.
But the co-occupancy, to acquire a right, I just had to cohabit with my spouse for the 2-year period. I had a right. And the analysis that Your Honors need to add in limiting and modifying, if you don't actually overrule Third Lennox, is how I lost that right once acquired. And the appellate term has never been able to answer that question. In the case below, they actually use the word inchoate. It's such an unfamiliar word to me. I'm not sure I'm pronouncing it correctly.
At what point then did the succession rights get acquired then, according to this timeline?
Well, if in our brief, as we explain, I think there are 3 or 4 different explanations as to when
I just give me a straightforward, when did the succession rights become obtained?
Assuming for the sake of argument,
yes,
that he obtained it on the 4th opportunity that we argue in our brief, that would be during the 2 years and more that he lived with Wanda Ramos, married to her. And in fact, the domestic relations law, which this court, the housing court, did not have jurisdiction over, agrees that by living with her.
Counsel, my point is, but that may be accurate, but you need at some point the tenant's vacatur, correct, to start the clock ticking.
And the vacatur, but for the Third Lennox rule, would be when she left the apartment. And then no clock ticks after that. It's an affirmative defense, which can be asserted at any time. There's no statute of limitations on asserting succession rights. So by living together for 2 years with Wanda Ramos.
This goes to counsel. This goes to what Justice Moulton was hinting at, or at least suggested, I think very clearly. Because of all this, what was going on here, it becomes very difficult to find out when is the actual date of vacatur. So you're putting the petitioner landlord in an untenable position of trying to figure out how do we start and when do we start measuring the time? Because it's a slippery fish in that sense. You're trying to grab a fish in this sense because there's just so much going on between 1990 and 2013. What is the period that we're going to actually be able to pick? Petitioner is not going to be able to do that because it's a moving target in that sense, and I don't think that's quite correct either.
Your Honor, actually, the date of vacatur, once you can prove the evidence by a preponderance shows that a right was required, the date of vacatur, but for the judge-made law of Third Lennox, the date of vacatur becomes almost irrelevant. And in fact, in another Second Department case.
Thank you very much. We'll hear from opposing counsel now.
Okay, thank you.
Any more questions? Does the bench have any more questions on this case?
Can I just give the site I was starting to give, Your Honor, and then I'll shut up. That's 700 Brooklyn Realty against Samuel, 69 Miss 3rd, 126, if I can read my handwriting, 126A. And it deals with a situation in which the date of vacatur in the past was not really clear.
Thank you very much.
Okay, thank you.
May it please the court, Philip Wartell from Rose and Rose for the respondent. The distinction between Third Lennox and Jourdain only addresses one question, and that's what's the 2-year relevant period that we would look at for purposes of determining a succession claim. Under the Third Lennox rule, it's 2 years from permanent vacatur, which is when a tenant surrenders, which in this case would be 2013. Even if the court in this case followed Jourdain, and I'll give several reasons why it should not in this particular case, even if it followed Jourdain, all that would do would change the 2-year period that we would look at. So we look at potentially at the absolute earliest when Ms. Ramos physically vacated the apartment, which was sometime in the mid-1990s, according to Susan Howard, summer 92, according to the discovery responses, or some other time in the early 1990s, according to Ms. Ortiz. Fine. If we look at the 2-year period prior to whatever that date is in the 1990s and said that was the relevant period, even if there was co-occupancy, they were not married. They still have to be either family members during the 2-year period of co-occupancy, or he has to prove a non-traditional family relationship. And in his own brief on page 29, he admitted that they were not claiming non-traditional succession. So there's no family member relationship during that period, and there's no non-traditional family relationship during that period. So regardless of whether we look at the period in the 1990s and 2 years before that, or 2013 and 2 years before that, the answer is the same. He cannot prove succession under the Rent Stabilization Code. And I'd also remind the court, he's actually not claiming succession under the Rent Stabilization Code here. This is only relevant if he's making a claim of succession under the Rent Stabilization Code. He's making a claim under the domestic relations law now. So this line of cases wouldn't even be applicable. I'd also remind the court that the appellate term didn't even base its decision on Third Lennox or any other case in its progeny. Rather, it made the determination based upon Mankiewicz in finding that he waived a succession claim by the severity and duration of a persistent systematic course of conduct that deprived the landlord of contemporaneous investigation. It was that concealment that resulted in a waiver. And I cite to many cases in my brief that those are two separate and distinct bases to deny claims of succession. One is where a tenant, for instance, continues to sign leases, that moves the permanent vacate date. It's a different analysis than Mankiewicz, where the question is whether a pattern of misrepresentations by an undertenant usually results in a waiver of an otherwise valid succession claim. Here, you don't have a valid succession claim, and even if you did, it would be otherwise waived under Mankiewicz. I'd also mention that even Jourdain makes note of Mankiewicz and carves out and references Third Lennox and Mankiewicz as exceptions, because it specifically referred to in Jourdain, it was one single renewal lease. So the court said, well, what's the prejudice to the landlord here? It's one renewal. The landlord knew that the daughter was there. There's no deprivation of a contemporaneous occupancy. And in Jourdain, they specifically say, in some of the cases interpreting Rent Stabilization Code 2523-5B1, is in the context of tenants who've moved out but continue to execute renewal leases have been concerned with fraud on the part of the tenant and prejudice to the landlord resulting from fraud. They refer to Third Lennox, they refer to Mankiewicz, and they say in this particular case, in Jourdain, it was one renewal lease before moving out of the apartment. And since the circumstances, the landlord was not prejudiced by any representation or delay. This is completely distinguishable. The landlord has been completely prejudiced by the extensive quarter-century delay and misrepresentation. That's what the appellate term based its decision on here, and that's the basis of this appeal. So Third Lennox is a different issue, and I don't think the distinction between Jourdain and Third Lennox have any bearing on the determination either at the trial level, at the appellate term, or here. I'd also mention, by the way, just in passing, another note, even if that were an issue, the question, because this Third Lennox is based upon an interpretation of the Rent Stabilization Code that deals with 2 years prior to permanent vacatur. Permanent vacatur is the specific language. It has it's a legal conclusion. We have to make the determination of what the permanent vacate date is. I'd also remind the court that in this case, I served a notice to admit. In the notice to admit, one of the facts I requested the respondent to admit to make it a non-issue at trial was that Wanda Ramos permanently vacated from the subject apartment as of August, I forget the date, in 2013. That fact was admitted in the response to the notice to admit. So there isn't even an issue before the trial judge as to when the permanent vacate date is. And once we have that permanent vacate date, the 2-year relevant period runs from the permanent vacate date. The permanent vacate date here was admitted by the respondent in response to the notice to admit. The 2-year period would run from the 2 years prior to that, which was 11 to 13. as Justice Oing indicated, there is no contemporaneous occupancy during that period, and the succession claim was properly denied either under Third Lennox, under Mankiewicz, or under any other theory.
Okay, do the justices have any other questions? Nope. Okay, thank you very much.
Thank you very much,
time.
Your Honors.
Thank you.
Thank you.
Oh, I'm sorry, I was muted.
Oh, you're still there? I'm sorry, Justice.
I was muted.
I'm sorry.
My apologies.
No, I'm sorry.
Muniz versus Chimiente.
Counsel for plaintiff is here, but
You're muted. Mr. Leiter, you're muted.
Yes, counsel for the respondent appellants, 1755 Jarvis LLC and Chimiente Realty Associates are here as well.
Why don't you begin? First.
Thank you, Your Honor. We are the cross appellants, but it's our contention that when the trial court issued its order 2 years after the jury's verdict was returned, it correctly recognized that the awards made by the jury were, quote, clearly excessive in light of the evidence at trial. But what the trial court should have recognized is during the trial itself that no fair verdict was going to be received. The defendants were unduly prejudiced by false claims of sexual abuse that never occurred, by the slanderous
Counsel,
references.
this is Judge Thing. Counsel, when those remarks were made, were curative instructions given?
A curative instruction was given by the court, but the motion that was made was first and foremost for a mistrial, and the curative instruction that was given was not sufficient. Sexual abuse was not a subject that was covered in voir dire because it was not anticipated to come up at this trial. It didn't belong in this trial. Additionally, even after it came up the first time, plaintiff brought it up several more times and gave the suggestion to this jury that he was then being unfairly prevented by the court from giving testimony about sexual abuse, when in fact there was no testimony to give because it never occurred. Defendants were unfairly maligned when they were called slumlord. Their assets.
And with respect to that claim, did you make a request for a mistrial?
There was not a request for mistrial as to that issue. But there were objections when there was an inquiry as to their assets, which had no relevance to the trial, and the court overruled those objections. And there was both objections and a ruling from the court before Dr. Sukoff took the stand, and a mistrial motion made, all based on Dr. Sukoff giving testimony based on hearsay with his review of a report of x-ray films that were not in evidence.
Did the court strike that testimony or not?
It did not strike all of the testimony. When defense counsel moved to have all of it stricken, the court declined, saying that the court wasn't convinced that all of the testimony that the defendant sought to have stricken.
So part of the testimony was struck. So the jury presumably listened to the judge during deliberations and didn't consider the parts that were struck, right?
Well, we have every reason to believe that the jury did consider materials that should have been stricken because the verdict that it returned was so excessive that even the plaintiffs themselves did not contend that this was a sustainable award. There was something that prompted that unsustainable award, and that something was the improprieties at trial, the sexual abuse allegation, the discussion of finances, the assertion of damages that had not been pled in terms of economic damages, the assertion of injuries that were not pled that were nonetheless presented. And so the excessive award, I think, has to be viewed not just in terms of what was the number that they put on it, but why did they get there? And the answer to that is because of what they heard at the trial that never should have been there. There was also, if I can switch now to the fact that the trial court made an award for past medical expenses when there was no amount of past medical expenses pled in the bills of particulars. There was no discovery of past medical expense claims during the discovery period.
Were there authorizations? Did you request authorizations?
We requested authorizations.
And what did you request in the authorizations? Did you request, for example, bills, et cetera?
The issue that we had was with the authorizations that were received. It's not that the authorizations were not compliant.
Sir, just answer the question. Did you request, did you get the bills in those authorizations?
We did not get the bills.
And then did you, sorry, go ahead.
Plaintiff's counsel knew that because when our expert witness was deposed prior to trial and the entire records that we received were presented, they naturally did not include any bills because we didn't receive any. Plaintiff themselves acknowledged that there were no bills that were exchanged or would have been received by processing those authorizations, and the only documents that they ever sought to introduce that identified any costs relating to the care were dated 2017. They weren't bills from 2011 being presented in 2017. They were bills dated 2017 for care that was received 6 years earlier.
Does have any more questions? Okay, why don't we hear from opposing counsel?
Good afternoon, Your Honors. I see you saved the best one for last here. When faced with a verdict of $8 million and 100% liability for the event that caused a life-altering injury to the plaintiff, the defendant wants you to look at all the peripheral issues that came up at the trial and not at the condition of the apartment. They want you to focus on a passing comment about taken advantage of, and they want to blow that out of proportion into a full-fledged claim for sex abuse. However, the jury received an appropriate instruction not to consider the vague statement. You would have to believe that this jury based its verdict on innuendos with that line of reason.
Well, your adversary contends that's the basis of the verdict. It's the statements and the prejudice and not the injuries, I guess.
This is a Bronx jury, Your Honor. A Bronx jury is not stupid. The testimony that the Bronx jury heard that created the $8 million verdict was that the building had constant leaks and ceiling falls, that the floorboard in the kitchen of the apartment was warped from the continuous water leaks in the apartment and from the washing machine above, that the bump in the kitchen grew and grew and grew because of water infiltration, that a year and a half before the incident, the bump was pointed out to an employee of Chimienti and nothing was done.
Counsel, that goes to liability. Why don't you address some of those more specific issues? For example, your adversary says, trial by ambush with respect to past medical expenses.
Well, Your Honor, I would just point out to you that they stipulated to the post-trial hearings on that matter. So they weren't concerned about it when they stipulated to the post-trial hearings. And they haven't actually presented a compelling argument to overturn the trial court's decision on the amount of the medical bills. They were there for both for the appearance that the judge scheduled. For them now to stand up and say, well, we don't think this is fair. They did that at the hearing, and they were overruled by the judge. I think that, the main point that I want to make is that they can't rely on all these peripheral issues to say that the jury came to this $8 million verdict because of those issues. The jury came to the $800 million verdict because of the condition of the apartment and because Chimienti's own witnesses were vague and equivocal when it came to the condition of the apartment. And the fact that the plaintiffs complained and complained and complained, this is a Bronx jury. This is what resonates with a Bronx jury. The condition of an apartment. This is the experience of Bronx jurors.
Counsel, you're absolutely plausible what you're saying, but we'll never know what went on in that jury room, so I wouldn't speculate.
That is correct. I completely agree with that, but that is their main point. Their main arguments are all speculative. Everything that, look, it's axiomatic that the judge who presides at trial is in the best position to evaluate the errors. That is what you just recently put in a decision that just came out in December. A jury verdict should not be set aside as contrary to the weight of the evidence unless the jury could not have reached the verdict by any fair interpretation. Let me just respond to the issue of damages. As for the value of the plaintiff's fractured tibia and fibula, this is still a state where you take the plaintiff as you find him. The fact that the plaintiff was diabetic at the time of the injury event makes the injury more disabling and more disruptive. Every complication that flowed from the original fractured tibia and fibula should be and was compensated by the jury. It is conservative in this particular case to award $1.5 million for future pain and suffering for a fractured tibia and fibula that also resulted in broken screws and further surgeries and complications in both legs. That's the other reason why the jury awarded $8 million. So all of the
so thank you very much for your argument. Thank you both for your patience.
No problem.
I just want to find out if everybody on Port Authority is still here or not. There was
Your Honor,
of argument, but
Your Honor, this is I'm the only party here. This is Paulo Alves for the Port Authority.
okay. Then we'll just call it a day with the argument.
Okay, thank you. I just wanted to wait.
Before I before I
Okay.
terminate.
Have a nice
Okay,
day.
session is now ended then. Thank you. You too.